will see a notification by RBI whereby before proceeding against a MSME, which is the micro, small, and medium industries under the Act, the RBI guidelines say that a special committee
Who
has
appears
to
for the
be
bank?
formed.
Who appears for the bank?
Yes, I appear for the bank.
What are your instructions?
Yes, I have instructions. This, a joint meeting was held. Joint meeting was held. We have circulated the minutes of meeting, asking him to produce the documents. This account was classified on 15th July 2025 as NPA.
No, 15th July 2025.
as NPA.
So if it is a MS, it is, you have given the loan for a MSME account, you are aware that it is an MSME.
May I pass on this minutes of meeting?
No, before issuing the notice, before declaring any asset as a non-performing asset, such a procedure to be followed.
Yes, it has been followed.
So that,
Madam, last 6 months, the unit is not operational. We have asked him to produce the documents. That unit is operational. What is a revival plan? Till today, it has not been submitted. Thereafter, it has been classified. May I pass on? And this minutes of meeting, the petitioner himself was present. He has all suppressed these facts. I'll file a detailed objections. If my lords are to kindly see
when
that.
was this dated? When was the meeting?
Lord, the meeting has to be under the stressed, as a stressed committee, and it has to
July 10th
consider.
to 2025. Have you mentioned about this in the affidavit? About a meeting dated July 10th, 2025?
They have nothing mentioned. They have not mentioned anything.
No,
and it has been rejected. It
One
has not
minute.
been feasible.
See, there is what I am saying. What I am saying is on 10th July, I wrote a mail where I stressed that a stressed committee under the MSME Act has to be formed. Despite that, in September, they have gone in violation of the circular, which is on page 37. So I've given 29th May 15 is the circular that says within the framework, no committee meeting within the framework of rehabilitation of micro, small, and medium. There is a judgment of the Supreme Court in pro nit, which I have referred to, and which copy
Get your,
my colleague
when
can
you file
pass
your
on to
objection?
your
Another week,
lordships.
1 week, my lord.
Huh?
1 week, my lords. Because there is an outstanding of 12 crores 85
That's
lakhs.
what we will consider.
Please.
The
And
respondent.
it has been rejected in November
The
2025, saying that
respondent
it's
shall
not
come up
feasible.
with their objections within a week. This is matter on,
Your ladyship, just give me
On-
protection in the meantime, because they are going under 13.4.
it is a
Which
contention of
is-
the land council appearing for the petitioners of which are the petition, the respondents are failed to follow the procedure as laid down with the honorable apex court in Pronit's case.
Even
It is
Pronit's-
denied by the learned counsel for the respondent.
Even if it should be before classification of NPA,
Correct.
they come after classification of NPA. The
The-
Pronit's case says that.
It's hardly a week. You come up with your objections and
Please.
decide the matter. It is submitted,
Yes.
and the same is denied by the counsel for the respondent. Considering the same, the respondent shall not take any coercive steps till the next date of hearing. Come up with your objections, we'll hear it.
It is outstanding of 12 point. Let them,
But,
plus
now,
all, may
I'll
make
check you.
one
What will
submission.
happen is, once your objections are on the record, we'll consider on the same day. I will not even, if you can, serve it before, let them, whatever they want to say, they'll say. I'll hear it on that day.
Plus, may I make one submission? All these are not MSME loans. They are auto loans, they are credit card loans, they are housing loans. They have merged everything in one end and they are submitting.
One more
it as
thing,
a-
I'm making it very clear on the, when you come up with objections, any of the facts which if they have suppressed, they'll be paying for it.
Please.
Yes.
All these facts, they have never, this meeting, they have not even
That's
mentioned in
what
their petition.
court will not take a lenient view. Now for all these 1 week of interim order they are enjoying, they'll pay for it, provided you can convince the court that there are suppression of facts before this
Please.
court. Yes.
Your Ladyship, grant us the liberty to file rejoinder to their
Huh?
liberty to file rejoinder to their objections.
Yes, it is the same shall be served on the counsel for the petitioner, and the petitioner shall file their objections if any to, or the rejoinder by the next date of hearing, and no further time will be granted. Yes, next.
Can it be,
Vinod Kumar, 18th.
Your Ladyship, can it be 16th or 17th?
No, 17th,
Which one,
Rishabh, I'm in Goa. It can be 16th.
Because they have to file, they have to file.
Because
you
I'll
have to
file
file
before 16.
16th
File
And
it
then
can
16.
be. Ma'am, 16th.
26.
56, Vinod Kumar.
For the petitioner. My lord, petitioner is the auction purchaser. He is a disabled person, my lord. He has purchased the property, however, 25% he has deposited. The possession is with the erstwhile owner, my lord. Only the bankers, they have the power to take the possession, my lord, under Surface Act, my lord.
What is, please come to the prayer.
My lord,
Straightaway,
prayer is
don't go to the
direction.
arguments.
Madam, seeking for
Fashion the notice dated issued to the respondent bank, threatening to forfeit the honest money deposited by the petitioner.
my lord, the possession is with the erstwhile owner, my lord. I have taken.
Is it so?
Lordship, I am submitting memo of undertaking. I may be permitted to file my objections and work.
Oh, that's true.
In the meanwhile, my lords, the property has been auctioned and 25% has been paid. Now the petitioner is contesting that the possession is with the owner. But now we have applied for the CJM order, which will be executed in future, and it can be delivered provided.
Why the bank is conducting like this? Are you supposed to take the possession of the property or not?
My
You are
lordship,
putting the
under
property
surface,
to auction.
under surface E, symbolic possession can also, sale can be posted, my lords.
Hmm.
I'll produce my
And later
objections
you
and
come to the court
I'll
and
rely
tell,
upon the High
no,
Court.
no, later you will not give the position to the
We will
auction
deliver
purchaser.
it, my lord.
And why should anybody enter into an auction with this kind of scenario? Where is the guarantee that they will get the position?
I may kindly be permitted to file my objections.
Huh? It is land counsel appearing for the petitioner submits that the petition is an auction purchaser. He has participated in the auction and paid 25% of the amount. It is submitted that even till now, the position is with the borrower. The respondents have not taken the position. And now they've issued a notice to forfeit the honest money. Land counsel so submits that he has instructions to file wakalat in this matter. It is submitted that they have filed an application before the magistrate and they are contemplating to complete the, now they're going to take possession of the property. In all the surface matters, the respondents or the person, nobody is coming forward to participate in the auctions because of this kind of an approach from the bank and approach from the bank. In these circumstances, there shall be stay of all further proceedings pursuant to the notice dated 2/2/2026.
Much obliged.
This next one.
27,
Appearing for the-
Shruti.
appearing for the petitioner, my lordship. The petitioner is challenging the e-auction notice, my lordship. It's an agricultural land. It's an agricultural land. They have issued
Bank is that?
It's a Kaveri Gramina Bank.
Just now, one matter is passed over about the maintainability of the writ against Karnataka Gramin Bank.
It's comes under the government, my lordship. It's a government established
There
bank.
is an order, we have to follow that. Pass over. Yes, 28.
28, Jetar Naik.
Petitioner in this case. Lords, the secured creditor, the bank, lords, is already under notice, lords, through the RBI. Lords, they've already ceased the operations.
Please come to the prayer.
Please, lords. Lords, to quash the possession notice and the consideration of my OTS scheme, please.
That we cannot tell them.
Or my representative, kindly appreciate what happens. Lords, during the course of, we are housing loan, lords, and other small business loans.
No. Why
Some
the-
other, my lords, debates.
That, why the possession notice has to be quashed by this court? What is the reason?
May I respectfully submit, my lords? Certain debits, my lords, and to my account, which are not pertaining to my account are made. So from day one, my lords, I've been seeking, please render me the correct account. You remodify my account, please render me the correct account and you tell me whatever amount I have to pay, I am ready to pay. I am not saying, please, my lords, I will run away.
13-2 notice is issued to you.
Please, my lords, I have already.
There is a reply to that.
Let's reply, please, my lords, that we have made several representations,
Now,
please.
let's see the reply.
Please, my lords, please, my lords. Lords, annexure F2, please, my lords, page number 81. Lords, we have represented to them, my lords, on several
Where
occasions.
is your reply? You can't call this a reply 81.
Lords,
Page 145.
140?
45 minutes. Annexure M, my paper book. N1. Subject is your position notice dated 30/5/25.
What is the reply to this?
Lord, they have not replied anything. Till today, they are not replying.
Who appears for the respondent? Which bank is this?
Caveat is filed.
Lord, this Guru Raghavendra Bank is under liquidation. Now, my lord, the RBI has taken over and appointed, please, my lords, one, my lords, what we call as the Registrar of Societies has looking after the affairs. The respondent number 2 is looking after the affairs. It is now, please, my lords, under liquidation. So RBI, please, my lords, and this respondent 1 and 2, please, my lords, are the authorities, please, my lords, to answer these queries. Not my respectful submission is, not let them give me the correct accounts. This has gone to liquidation for, my lords, a large scale fraud that has been played on the public. That is why this bank.
What do you say about the maintainability of the writ petition against
now, my lords, when they have
private
played,
bank?
now, my lords, RBI has taken over, please, my lords. RBI has, the Registrar of Societies are now running the day-to-day affairs of the bank. My lords, the entire amounts are freezed. So wherefore, please, my lords, it would be maintainable, please, my lords, is my respectful, humble submission. Now, my lords, if they don't render me the current account, where will I go, please, my lords? In the usual course, please, my lords, if it is a bank which is operating, please, my lords, I understand, my lords, I'll have to go avail my remedy, please, my lords, before the DRT. Here, my lords, affairs are taken
Emergency
over.
notice to all the respondents.
I will take notice for respondent number 2.
Huh?
I will take notice for respondent
Respondent
number
number 2, so your
2. SCGP. Ma'am.
SCGP takes notice.
My lords, I may be permitted to serve on the standing counsel for R1, please, my lords, and R3. May I
Petition
request?
is permitted to take out handsome on the council appearing for the first respondent.
Previous proceedings, my lord,
Third
Mr.
respondent,
In the previous proceedings, my lord, that is at page 165. For respondent number 1, my lord, Shri Nitin Prasad was represented.
then you let it go. Yes, next.
29.
I may be permitted to move the court immediately, please, my lords, after I complete service.
For the
Mohan.
petitioner in the matter, my lord. My lord, petitioners are the wife and the son of the deceased main borrower, my lord. My lord, on 7th July, my lord, 2024, the main borrower passed away. Subsequently, the surface proceedings have been initiated. My lord,
Yes,
On
Mr. What's his name? Nandish Patil. Now, what is this, again, the main, how the writ petition is maintainable against this? What is the latest law on this? One is Sanman Capital Limited.
Please, my lord, there are 2 judgments, my lord, of not dishonorable court, my lord, of
No, this honorable court also, there is one of
yes,
Justice
my lord,
G.
against a
Narendra.
private Kerala High Court, there is one judgment.
G. Narendra's judgment is against Karnataka Bank.
My lord, where, my lord, the courts have held that against private NBFCs, my lord, writ is not maintained.
Any Supreme Court judgment?
No, my lord. There are 2, one Kerala High Court judgment is there, my lord, and I think one.
No, because what are these Samman Capital Limited, known as India Bull Housing Finance?
NBFCs, my lord, they're all NBFCs against which writ is not maintainable. There are 2 judgments. I will, lordship may pass it over, my lord, I will praise those.
Just pass over. Next.
Dorai Raju.
My lord, I appear for the petition in this case. The prayer of my writ petition is I have sought for stay of the auction sale notice of the first respondent, that is the Chief Executive Officer, Surabhi Sauharda Credit Cooperative Society.
Who is that?
The first respondent in this case is,
Chief Executive Officer, Surabhi Southern Credit Cooperative Society.
yes, my lord, my submission to your lordship is, the petitioner is a homemaker. She has purchased a site measuring 60 by 36 feet in the judicial layout from the Karnataka Judicial Employees House Building Cooperative Society in the year 2001. The sale deed is at Annexure A and B. My lord, she constructed a house there and was living along with the family. The fourth respondent along with others, approached her and obtained Xerox copies of her house property. Took that to the fifth respondent, obtained a loan of 1 crore 85 lakhs.
All these disputed questions of fact, we cannot decide here.
True, true. Your Lordship may kindly see, a case is already registered by the police and these fraudsters are arrested by the Central Crime Branch, Bangalore Police, and they are going to place the charge sheet text week. That is one thing. Secondly, the other orders passed by the DRT is challenged by the petitioner before Debt Recovery Appellate Tribunal, Chennai. The matter is pending for adjudication. Meanwhile, your Lordship may kindly see, the first respondent, without observing the pendency of the other cases and also without scrutinizing the documents in the Kata certificate issued by the BBMP, the name of the petitioner, another person's name is clearly mentioned. The property is in the joint name. In spite of that, the first respondent, without going through the documents and without obtaining the
Please
legal opinion.
Take out emergent notice to all respondents.
My lord,
This
my
is
lord,
matter
my
after
submission is, my lord, action is fixed tomorrow. This helpless lady is struggling too much. I pray your lordship to kindly stay the action for a short period because it leads to multiplicity of litigation. She is penniless and she lost a valuable house. She has not taken a single pie. She's a guarantor. She is not the principal borrower. Principal borrowers and
Oh,
others.
just now you said that some scam has been played. Now you're saying that she is a guarantor.
Well, my humble submission is the fact is there. It is I have produced all the records before your lordship. She is a guarantor, but she has not signed as a guarantor. This fifth respondent took her to the sub-registrar. Sub-registrar also accused.
So,
Chief manager of the bank is also.
As per the record, you're a guarantor. The liability of the principal borrower and the guarantor is coextensive.
True, my lord. I am not a guarantor. On some pretext by misrepresentation, they took me to the sub-registrar, got the papers
Question of
signed.
fact, which has to be
My lord,
established.
therefore, a complaint is lodged before the police and we have approached the Honorable High Court. Honorable High Court directed for the investigation and the matter is being seriously investigated. The fraudsters are arrested by the CCB police and the DRT appeal is also pending. Meanwhile.
Then why can't you go before the DRT? Why should you come before the High Court?
True, my lords. It is pending there, my lord. Today, I have seen the newspaper. The property is subjected for e-auction sale. Tomorrow is the e-auction. And I have filed a representation before the first respondent. They refused to accept the representation. The representation, the postal acknowledgements, the translation of the representation, everything I have filed before this honorable court. I have a very
What
good
is the outstanding amount?
The first loan is 1 crore 82 lakhs. On two different dates, they granted the loan to the fourth respondent, Tarun Traders, without my knowledge, consent and information, my lord. That is being challenged and the case is registered, they are arrested and the matter is pending investigation. It is totally a fraud transaction, misrepresentation and cheating.
Before the DRT will decide all this.
True, my lord.
But we can't do.
True.
I'll permit you to go to DRT. I can grant you 10 days
My
time.
lord, one submission I
I'll
will.
grant you 10 days time, not more than that.
10 days time, please, my lord.
Give the file. The present writ petition is filed, seeking the following reliefs. It's a case of the writ petitioner. The petition is the owner of his residential property, bearing number 2093, measuring 2160 square feet, situated at Alessandra, Chickbaum Samadra and Jakut Plantation, formed by the Karnataka State Judicial Department employees, House Building Cooperative Society. She purchased the property by a registered sale deed dated 4/12/2009. And after purchasing the property, she has constructed a residential house. The fourth respondent promised the petitioner that he approached the fifth respondent bank for loan and he has given his property as security towards the loan to be sanctioned in his favor. He further requested the petitioner to stand as the surety guarantor for the loan to be availed by him from the fifth respondent bank by producing only Xerox copies of the documents relating to the property and assuring that there will be no recovery or any action against the property. The bank has granted an overdraft of 2 crore 20 lakhs. It is submitted that as a fifth respondent has failed to pay the amount, the bank has initiated the recovery proceedings and put the property to sale on 11/11/2021. From when this is going on?
Madam, 5/3, day after tomorrow.
It's not that. You have been, this proceedings have initiated when, from 2021,
Yes, my lord.
and now you are coming to High Court.
No, my lord, it was pending before the DRT. Several writ petitions were filed before this order report. There are directions, and
The
also
writ petition is filed seeking the following prayer.
that a month's time, kindly
No,
with that.
the writ petition is filed seeking the following prayer. The petitioner has stated that there is a fault played on the petitioner. In that regard, he has already given a criminal complaint. And when an order is passed for the DRT, he has filed an appeal before the DRAT. Now it is submitted that the bank has issued the sale notification, and there may be a direction to stay all further proceedings as the investigation is in progress and they're going to file the charge sheet. The recovery proceedings, having heard the counsel for the petitioner, the recovery proceedings were initiated in the year 2021. From 2021 till now,
My lords, I may be permitted for interference. My lord, the first recovery proceedings is already auctioned and property illegally was taken over by the Union Bank of India, that is the fifth respondent. My lord, subsequently, the first respondent granted a loan illegally without following the pendency of the cases, and that matter is being now, they have taken up and for action.
The petitioner, having gone to DRAT, questioning this notice, ought to have approached DRT. This is the case where more than a crore amount is granted as a loan, and it's a public money. If according to the petitioner, there is a fraud paid by them, the petitioner can establish the same before the appropriate forum. This court cannot interfere with the auction process. In that view of the matter, this court do not find any reasons to interfere. Accordingly, dismissed, giving liberty. Accordingly, this court is passing the following order: the petition is dismissed. However, petition is at liberty to avail the appropriate remedy. Yes, next.
31, Prasanna Kumar.
For petitioner in this matter, my lords. Lords, petitioner number 1 has taken rupees 30 lakhs loan from the respondent bank, my lords. Subsequently, he has discharged the entire loan liability, which my lords may find it Annexure E, my lords, page number 50, my lords.
This also in the afternoon about maintainability of the writ petition.
My lords, the Raghavendra Bank, my lords, which is due to mismanagement in the bank, RBI has issued regulatory.
That's what, that matter also will hear.
My lords, I sought for stay, my lords.
Afternoon.
Much older.
And you have to please get judgments to show that the writ petition is maintainable. Otherwise, I'm going to dismiss the writ petition on the ground of maintainability.
Much older.
In the light of the judgment of this court. This court is the coordinate bench of this court. Yes.
32, 33 passed over. Answer Arjun. 34.
Appearing for the petition, my lord. Appearing for the petition, my lord.
For number 4.
You appear for the petitioner?
I'm appearing for the petition, my lord.
Yes.
My lord, this matter arises from RERA. In RERA, the home buyer had sought for refund. I had challenged that in an appeal before RERA Appellate Tribunal. In Appellate Tribunal, there was a compromise, joint compromise, that my lord will find at Annexure B, page number 45, my lord. Page number 45, if my lord will turn to para number 4.
You are questioning a notice dated 23/9/2021 issued by the third respondent. Who is the third respondent?
Tahsildar.
Tahsildar, my lord.
Seizure order.
My lord, there was a decree passed under the by the RERA under the joint compromise degree. Based on he did not comply that amount, so that there was a direction to recover that amount under the Karnataka Land Revenue Act, by which that impugned order notice is passed issued, which is under page number 65 next H. It was a joint compromise.
May I make my submission, my lord? I'll be able to
No.
assist this honorable court.
Yes.
My lord, if my lord will see page number 46 of the writ petition, the joint compromise which happened before RERA Appellate Tribunal, the amount is 1,75,000. And then at para number 5, it is mentioned on page number 47, time is essence, that within a particular time frame, this 1,75 lakh should be paid. Somehow that amount could not be paid. Then what happened, my lord? Now, the home buyer, without writing a letter to me, writes a letter to RERA to modify the recovery certificate. That, my lord, will find at Annexure E, the recovery certificate. There the amount, because I had already paid part of the amount as deposit in my RERA.
One minute. Let me look at the parties. Who are you?
I'm the builder, my lord. I'm the builder.
You are the builder.
Petitioner in
Yes.
this writ.
1 minute. Where is the cost title? Page number?
My lord,
17, my lordship.
Cost title on page number
17.
17.
Deputy Commissioner, Special Teaser. 4 is
And
the?
4th is the home buyer.
So there was an agreement between you and the purchaser.
Yes, my
Let
lord.
us
That,
see
my
what are the
lord,
contents of the agreement.
Now that, my lord, will find at Annexure B. This joint memorandum of compromise happened in RERA Appellate Tribunal.
Let's read the contents of the joint compromise. Yes.
Shall I read from para number 1, my lord?
54.
Yes.
Operating
page
portion
number
54.
45.
Let's read 54.
54? Okay.
Yes.
54.
My lord, page number 54 is the order, my lord. Page number 45 is Annexure B, where the joint memorandum of compromise is there.
Directed to release the amount.
That is the order, my lord, of RERA. RERA Appellate Tribunal.
Yes.
The compromise is at page number 45. Based on this, that order was passed.
Yes.
The appellant has filed, page number 45, my lord, para number 1. The appellant has filed the above appeal challenging the order dated 11/2/2020 passed by the educating officer K. RERA in CMP number dash, awarding refund of rupees 1,17,14,100, together with interest at 9% per annum on the respective amount paid on respective date till 30/04/2017 and at the rate of 2% above MLCR of SBI commencing from 1/5/2017 till realization of entire amount. The Honorable Tribunal has imposed cost of rupees 5,000 to be paid by the appellant to the respondent number 2. Further, the challenge is to recovery certificate dated 24/7/2020 issued by Additional Secretary K. RERA. The appellant has deposited before this Honorable Appellate Tribunal a sum of 55,24,000 on 27/11/2020. In pursuance of the impugned order dated 11/2/2020 of the Educating Officer K. RERA, a recovery certificate dated 24/7/2020 was issued by Additional Secretary for the recovery amount of 1,84,12,240. My lord, if my lord can just note down this amount. First recovery certificate, 1,84,12,214 rupees. Number 3, the above appeal was posted on 17/12/2020.
I read that paragraph. Come to 4.
Up to 4. The appellant has offered to pay a sum of rupees 1,75,00,000 as full and final settlement of all the criminalizing out of the impugned order dated 11/2/2020 passed by the Honorable Educating Officer so and so to the respondent number 2, who is respondent number 4 here. in a time-bound manner as stated herein on the said assurance of the appellant. Respondent number 2 has agreed to accept the offer to settle the matter amicably by receiving a rupees 1,75 lakh in the following manner. Now, the different dates are given, my lord. A, the appellant has no objections in the respondent number 2 withdrawing this 55 lakh which I had already deposited before RERA appellate tribunal. B, out of the remaining sum of rupees 1,19,76,000, appellant shall pay the respondent number 2 a sum of rupees 30 lakh on 31st January 2021. Out of the remaining 89, the appellant shall pay the respondent number 2 30 lakh on 28 February 2021. The appellant shall pay the final 59 lakh 76,000 on or before 31st March 2020. Now, these were the timeline, my lord. Now, what has happened during this? They withdraw the amount, and in para number 5, they say that time is the essence. After withdrawing the amount, somehow this amount could not be paid during that timeline. The respondent number 4 writes to the RERA and gets the recovery certificate chain. Now, the calculation which is provided to RERA by the home buyer is wrong, my lord. That, my lord, will find at Annexure G, and the tabular compilation is on page number 63, my lord. Page number 63. It is only a small point, my lord. That is, the home buyer has calculated interest on interest. That's all the point is. Today, as on today, my lord, I have paid an amount of 1,85 lakh. My lord had noted the compromise was for 1,75 and recovery certificate was for 1,84. I have paid 1,85 lakh 16,389 rupees. Now, here the home buyer is calculating interest on interest. That I will show, my lord. If my lord can take page number 63 of the writ petition.
So, as per the timeline, when are you supposed to complete your last payment?
My lord, as per the agreement, 31st March 2021. 31st March 2021.
31st March
2021, my lord. And what happened?
Then what is wrong with the order? What is wrong with the order? Why should we set aside that?
No, my lord, I have paid. This writ petition has actually become infructuous. That's my humble submission. I have already paid. I have paid 1,85 lakhs. The compromise was for 1,75. The first recovery certificate was for 1,84 lakhs. I have paid 1,85 lakhs today. Only unfortunate thing is,
this notice was issued on 23/9/2021. By that time, how much amount you have paid?
My lord, in this writ petition, I filed a memo of undertaking that I will pay the amount, and I paid the entire amount, my lord. That is my humble submission. After filing this writ, I said I will pay the entire amount, and I paid the entire amount.
So why did you file this writ petition? That I am not able to understand.
My lord, because of what has happened. Okay, sir, go on.
Yes, yes, please tell.
My lord, may I?
I'm asking you.
Yeah, my lord, I had filed this writ petition because the first recovery certificate is issued for one amount. Behind my back, there is another recovery certificate issued without issuing notice to me. Based on the calculation of the respondent number 4 home buyers, the amount is changed. Now, at least if you are changing the amount first, let me know. And the calculation is wrong. That is why this writ petition was filed. Nevertheless, I had to pay the amount. I have paid the amount, my lord.
No, this court has to determine.
That is what was recorded by this honorable court on 22/7/2024. That the petitioner has paid the entire amount.
No, we have to calculate now whether the amount is paid by you or not.
Yes, my lord. The respondent number 4 is disputing that I have not paid, and I have proved to this honorable court on the last date also that I have paid, and this matter requires consideration.
Whoever has to execute the decree, they will see about the calculation. They are not for this court to look at the calculation.
My lord, only my humble submission is, as per the undertaking, whatever the amount which was there, I have paid that. And I
You are
can
questioning
very well
the
demonstrate to this honorable
order
court.
dated 11/10/2021. We are only on the point, what is wrong with the order dated 11/10/2021? And about the final notice. You are only on the point that I have already paid, and where is the calculation? What are your objections to the notice?
My lord, if my lord can take my memo dated 24/6/2024. From day one till today, what has happened, I have crisply put it in my points. What has happened. And I just want to demonstrate why this is wrong. It's a very short point, my lord. If I can just take 1 minute of my lord and show one point, this matter will be over, my
Before
lord.
you go to all these submissions, come to this notice dated 23/9/2021, page number
65.
Yes, my lord.
What it says.
May I read, my lord?
Please.
The operating portion at 66. Before that, it will start from ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿ ಶ್ರೀಮತಿ ಆರ್.ಜೆ. ರಿಷಿಕರಣ್ ಪ್ರಾಪರ್ಟೀಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ so and so ಅದು ನಿಮಗೆ ಉಲ್ಲೇಖಿತ ಕಾರ್ಯದರ್ಶಿಗಳು so and so ಅವರಂತೆ. The arrears of amount was 1,84,12,214 ಗಳನ್ನು ವಸೂಲಿಗೆ ಆದೇಶಿಸಿದಂತೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಬೆಂಗಳೂರು ನಗರ ಅವರ ಕಾರ್ಯಾಲಯದಂತೆ so and so ಈ ಸಂಬಂಧ ತಾವು ಈ ಕಚೇರಿಗೆ ಲಿಖಿತ ದಿನಾಂಕ 16/12/2020 ಲಿಖಿತವಾಗಿ ನೀಡಿರುವ ಮನವಿಯಂತೆ ನೀವು ಕಟ್ಟಬೇಕಾದ ಒಟ್ಟು ಮೊತ್ತದಲ್ಲಿ 30% ಅಂದರೆ 55,24,000 ಗಳನ್ನು ರೇರಾ ರಿಜಿಸ್ಟರ್ ಕರ್ನಾಟಕ ಸೋನ್ಸೋನು ಪಾವತಿಸಿದರು ತಿಳಿಸಿದ್ದಾರೆ. ದಟ್ ದೇ ಹ್ಯಾವ್ ಪೇಡ್ ದಟ್ ಅಮೌಂಟ್. ತದನಂತರ ಬಾಕಿ ಹಣ ಪಾವತಿಸಿರುವ ಬಗ್ಗೆ ನೀವು ತೆಗೆದುಕೊಂಡ ಕ್ರಮದ ಬಗ್ಗೆ ಈ ತಹವಲುವರೆಗೂ ಯಾವುದೇ ಮಾಹಿತಿ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಮೇಲ್ಕಂಡ ಬಾಕಿ ಹಣವನ್ನು ಅಂತಿಮ ನೋಟಿಸ್ ತಲುಪಿದ ದಿನದೊಳಗೆ 15 ದಿನಗಳೊಳಗೆ ಬಾಕಿ ಮೊತ್ತವನ್ನು ಕಾರ್ಯದರ್ಶಿ ಕರ್ನಾಟಕ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ನಿಯಂತ್ರಣ ಪ್ರಾಧಿಕಾರ ಬೆಂಗಳೂರು ಇವರ ಹೆಸರಿನಲ್ಲಿ ಡಿಡಿ ರೂಪದಲ್ಲಿ ನೀಡುವುದು ಅಥವಾ ಖಜಾನೆ 2 ಅಲ್ಲಿ ಕರ್ನಾಟಕ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ನಿಯಂತ್ರಣ ಪ್ರಾಧಿಕಾರದ ಸೋನ್ಸೋ ಅಂತ ಜಮಾ ಮಾಡುವುದು. ತಪ್ಪಿದ್ದಲ್ಲಿ ನೀವು ಈ ಮೇಲ್ಕಂಡ ಭೂಕಂದಾಯ ಬಾಕಿ ಎಂದು ಪರಿಗಣಿಸಿದ ಮೊತ್ತವನ್ನು ಪಾವತಿಸಲು ವಿಫಲವಾಗಿರುವುದೆಂದು ಭಾವಿಸಿ ನಿಮ್ಮ ಹೆಸರಿನಲ್ಲಿರುವ ಚರಾಸ್ತಿಗಳನ್ನು ಸರ್ಕಾರದ ವಶಕ್ಕೆ ಪಡೆದು ಸ್ವತ್ತನ್ನು ಜಪ್ತಿ ಮಾಡಿ ಸದರಿ ಸ್ವತ್ತನ್ನು ಬಹಿರಂಗ ಹರಾಜು ಮಾಡಿ ಬಾಕಿ ಹಣವನ್ನು ಪಡೆಯಲಾಗುವುದೆಂದು ತಿಳಿಯುವುದು. ಸದರಿ ನೋಟಿಸ್ ಅಂತಿಮ ನೋಟಿಸ್ ಆಗಿರುತ್ತದಂತಹ ತಿಳಿಯಪಡಿಸಿದೆ ಎಂದು ಈಗಾಗಲೇ ಅಂತಿಮ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಲಾಗಿದ್ದು, ಈ ಸಂಬಂಧ ನೀವು ದಿನಾಂಕ 2/8/2020 ಅರ್ಜಿದಾರರಿಗೆ ಪಾವತಿಸುವ ಮೊತ್ತ 1,75,00,000 ಈಗಾಗಲೇ 84,84,24,000 ಗಳನ್ನು ಪಾವತಿಸಿದ್ದು, ಉಳಿಕೆ 89,76,000 ಗಳನ್ನು ಪಾವತಿಸಲು ಸಿದ್ಧವಿರುವುದಾಗಿ ಸೂಚಿಸಿ ಪತ್ರ ಬರೆದಿರುತ್ತೀರಿ. ಸದರಿ ಪತ್ರದ ಪ್ರತಿಯನ್ನು ಸೋನ್ಸ್ ಅಂತ ಕಳಿಸೋದು. ನಿಮ್ಮ ಪತ್ರಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಅರ್ಜಿದಾರರು ಸಹ ತಮ್ಮ ಪತ್ರದ ಮೂಲಕ ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿದ್ದು, ಸದರಿಯವರು ತಮ್ಮ ಆಕ್ಷೇಪಣೆ ಪತ್ರದಲ್ಲಿ ಒಟ್ಟು 1,15,31,759 as on 9/8/2021 ಗೆ ಪಾವತಿಸಬೇಕಾಗಿರುತ್ತದೆ. This is the amount that they were supposed to pay on as on 9/8/2021. ಪೂರ್ತಿ ಮೊತ್ತವನ್ನು ಪಾವತಿಸುವ ಕೊನೆಯ ದಿನದವರೆಗೂ ಬಡ್ಡಿಯೂ ಸಹ ಒಳಪಟ್ಟಿರುತ್ತದೆ. ದಟ್ ದಿಸ್ ಅಮೌಂಟ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ದಿ ಇಂಟ್ರೆಸ್ಟ್ ಆಲ್ಸೋ. ನಿಮಗೆ ಬರೆದ ಪತ್ರದ ಪ್ರತಿಯನ್ನು ಈ ಕಚೇರಿಗೆ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಈ ಮೂಲಕ ತಮಗೆ ಅಂತಿಮವಾಗಿ ತಿಳಿಯಪಡಿಸುವುದೇನೆಂದರೆ, ಈ ಪತ್ರ ತಲುಪಿದ 10 ದಿನಗಳೊಳಗಾಗಿ ನೀವು ಅರ್ಜಿದಾರರಿಗೆ ಪಾವತಿ ಬೇಕಾದ ಪೂರ್ಣ ಮೊತ್ತವನ್ನು ಬಡ್ಡಿಯೊಂದಿಗೆ ಪಾವತಿಸಿರುವ ದಾಖಲೆಗಳನ್ನು ಈ ಕಚೇರಿಗೆ ಹಾಜರುಪಡಿಸಲು ಸೂಚಿಸಿ ತಪ್ಪಿದ್ದಲ್ಲಿ ಬಾಕಿದಾರಿಗೆ ಬಾಕಿ ಮೊತ್ತವನ್ನು ಪಾವತಿಸಲು ವಿಫಲವಾಗಿರುವ ಎಂದು ಭಾವಿಸಿ ಜಪ್ತಿ ಆದೇಶವನ್ನು ಹೊರಡಿಸಲಾಗುತ್ತದೆ. It's the substance of the notice that there was a due of amount of 1,15,31,715 as on 9/8/2020. If you have paid it, give us details. We will close it. If you have not closed, we will proceed as per the Karnataka Land Revenue Act recovery.
He has come before the court.
Yes, ma'am. He claims that he has paid it.
My lord, before going to that annexure number H, that is dated 23/9/2021, let's get to annexure G, which is dated 9th August 2021. Just let's have a look at it. Now, how did this sum of 1,15,31,000, which is coming in the...
Are you not supposed to reply to that notice?
My lord.
If he has paid, my lord.
Now, I have said that this is wrong. I have very well said that.
We are not concerned with all that. Why are you really litigating from 2022 without giving a prompt reply where you are supposed to give?
My lord, because that's a wrong calculation. That is a wrong calculation.
You should tell him You should tell him that it is wrong. Why should you come to the High Court?
My lord, that time I challenged this because without issuing notice, he has issued this letter that you are supposed to pay. At least
No,
if I am supposed to pay.
whatever calculation, whatever it is, go and tell the Tehsildar. We will not decide all this. Please come.
Sure. That is okay, my lord.
And whatever is the interest, whatever interest that is accrued till today because of the litigation, you will be paying. That I'll make it sure.
My lord, that cannot be because I have already paid the entire amount. Now, the whole point is the interest calculation is wrong. And if my lord will give me 1 minute, I can show based on what other orders RERA has passed and this gentleman calculated on his own.
No. When this order is passed in 2022, have you given a reply to the Tehsildar? Things would have been settled by that time. Don't do it. Come before this court, just like that. And keep the matter pending from 22 to 26, and who will answer to that? So whatever
I have already paid during the pendency of this matter. If my lord will see the.
Why should you pay? Why should you pay why should you pay during the pendency unless and until the present petition is filed?
I have paid much more than the joint memorandum of compromise.
That the Tehsildar will decide now. Tehsildar will decide now.
Let him decide, my lord. There is no problem in that.
Yes. The petitioner, the petition is filed. It's a case of the petitioner that a joint development agreement dated 26/5/2013 was entered with the owners of the land to take up a residential project consisting of the 2 basement floors, ground floor and 27 upper floors. The total number of apartments in the project is 173, consisting of 3 and 4 bedroom apartments in 2 towers. The petitioner's share is 63% of the super built up area, that is 112 apartments, and the share of the landowner is 37%, that is 61 apartments. After getting the necessary permissions, the petitioner entered into an agreement to sell with the 4th respondent and the owner of the land in respect of 579.41 square feet of undivided interest in the land for a sum of rupees 31,84,890 corresponding to apartment bearing number 503 on the first floor on B block, having a super built up area of 2123 square feet along with 2 covered parking spaces.
Respondent paid 1 crore 17 lakh.
Not voice, the petitioner was not in a position to complete the project within the intended timeline due to various factors beyond the control of the petitioner. The 4th respondent filed a complaint under section 1831, read with section 71 of the RERA Act, seeking the relief or registration of the flat, providing amenities, occupancy certificate, interest, costs and damages. During the pendency of the proceedings, the 4th respondent filed a memo dated 12/12/2019 seeking amendment of the prayer to withdraw from the project and soft refund of the amounts paid by him with interest. Despite the objections, the adjudicating officer of KRERA partly allowed the application on the 4th respondent by judgment dated 11/2/2020. The adjudicating officer ordered for return of rupees 1,17,14,100 together with interest at the rate of 9% on the respective amount paid on the respective dates till 30/4/2017 and 2% above MCLR of SBI commencing from 1/5/2017 till realization of the entire amount. And in the said judgment, the 4th respondent was also directed to execute a deed of cancellation or the agreement of sale after realization of the entire amount. It is stated that the 4th respondent managed to obtain the recovery certificate with inflated figures and an attempt was made by him to execute the same. In that context, he was constrained to file an appeal under section 44 of the RERA Act. Before the RERA appellate authority, a compromise was entered between both the parties by filing a compromise petition dated 23/12/2020. Under the said compromise, the petition was required to pay 1 crore 75 lakhs as full and final settlement in pursuance of the impugned order dated 11/2/2020. The petition had deposited a sum of rupees 55,24,000 before the appellate tribunal, which was ordered to be withdrawn by the fourth respondent along with the accrued interest. The fourth respondent has since withdrawn the said amount, however, has not disclosed as to the amount of accrued interest received by him. Therefore, the amount due after the fourth respondent collected the amount was rupees 1 crore 75 lakhs minus rupees 55 lakhs 24,000 is rupees 1 crore 90 lakhs 76,000. Then the fourth respondent filed a memo dated 23/11/2020 for withdrawal of the amount in deposit. According to him, according to the petitioner, a sum of rupees 30 lakhs was paid on 8/2/2021. As such, the KRERA issued a letter dated 14/7/2021 to the third respondent for recovery of rupees 89,76,000. On receipt of such communication, the petitioner sent a letter to the fourth respondent dated 2/8/2021, calling upon him to visit the office of the petitioner with the original of the agreement, and the balance amount of rupees 89,76,000 will be made, and requested the fourth respondent to inform the date and time of the meeting. The fourth respondent has sent a letter dated 9/8/2021 along with the calculation sheet claiming a sum of rupees 1 crore 15 lakh 31,759. It is stated that the fourth respondent has sent a letter to KREAT dated 26/7/2021 to correct the figure in the letter dated 14/7/2021 to the Tehsildar. It is stated that the fourth respondent appears to have given a representation dated 10/8/2021 to the special Tehsildar. Third respondent here and requesting him to revise the quantum of the amount to be recovered, and the same was incorporated in the final notice dated 23/9/2021, asking the petitioner to pay rupees 1 crore 15 lakh 31,759. It is stated that the Tehsildar did not have the jurisdiction to fortify the figure unilaterally without notice to the petitioner.
Allowed on submission.
It is stated that
Since he did not reply the notice dated 23/9/2021, which was resulted in issuance of attachment warrant void letter dated 30/12/2020, which your lordship will get it.
that will in
Yes.
your submission side.
Yes.
Then it is stated that the adjudicating authority has passed an order dated 11/10/2021, revising the amount to be recovered from rupees 89,76,000 to rupees 1 crore 15 lakh 30,055, purporting to exercise power under section 40 of the RERA Act, read with rule 25 of the rules, with future interest at the rate of rupees 10.15% simple interest on rupees 1 crore 38 lakh 54,652 from 8/10/2021 till realization. It is a case of the petitioner that the first respondent did not issue any notice to the petitioner before passing the order dated 11/10/2021. It is stated that the first respondent sent a communication dated 24/11/2021 to the second respondent deputy commissioner to recover a sum of rupees 1 crore 15 lakh 30,055 as arrears of land revenue and remit the same to RERA along with the recovery certificate for rupees 1 crore 38 lakh 54,652 with simple interest at 10.15% from 8/10/2021. It is stated that in view of the various discrepancies in the claims made by the fourth respondent and the notices issued by the second and third respondent, the petitioner submitted a representation to the chairman of the first respondent dated 20/12/2021, requesting him to provide an opportunity to produce all the relevant documents to establish the discrepancies. But the chairman has assured that he would fix a date for the said purpose. However, he has not stayed any proceedings in pursuance of the revised recovery certificate.
That is why, my lord, before you.
It is a grievance of the petitioner that without a notice to the petitioner, the revised certificate was issued by the first respondent, and basing on that, the third respondent has initiated the proceedings, which is, it is a unilateral modification of the revenue recovery certificate by the adjudicating officer and the carrier. Hence, a petition is before this court. Now,
My lord.
when a compromise is entered into between the parties,
Yes, my lord.
with regard to the amounts and all,
My lord.
before
Appellative.
I mean,
There are-
issuing the certificate, is it not necessary that they should look, the concern should be put on notice?
They were not paid before. They were paid before this court.
At least you are revising the amount. At least let me know. I can put
What
forward
happened?
claims. But
Just
my, I
wait a
was not
minute,
given
wait a
an
minute.
opportunity, my lord.
Wait a minute, Mr. Counsel, yes.
Lord, admittedly, it was a joint memo.
Huh?
It was a joint memo. Thereafter, there was a due up amount. Though the RERA has written a letter directing us to take action in accordance with the law, by which we have issued a notice.
For the Tehsildar. No, Tehsildar has no independent power. Whatever is the recovery certificate that is issued by the authority, that is the first respondent, you will be executing it, isn't it? You have no independent power. You're like more or less an executing court.
Yes, yes, no independent powers. Only we
So
can
you will
recover under
be-
the Land Revenue
You will
Act.
be going by the same.
Yes.
Now, when in an amount of 1 crore 17 lakh, 1 crore, what is the
70.
initial amount?
1 crore 75
75
lakhs.
lakhs. 75 lakhs.
75 lakhs, 55 lakhs is already recovered. They have withdrawn from the, which is deposited before the
Deposited into
RERA.
the-
So they have already withdrawn. So basing on why they have now added the amount, they should issue when they're giving their certificate, isn't it?
Lord, they ought to have replied to the notice dated 23/9/2020. That
But you can do.
no, they have. See, we have issued a notice.
So let's assume that, like, he has not given the notice. If he gives the notice, what will you do?
Now, by virtue of the notice, the direction issued by the RERA, the notice under dated 23/9 was issued.
You have issued. Now he will reply to you.
Let him reply because there was some malady.
Understand the court's query, Mr. Counsel. I'm saying he will issue the reply to you. What will you do? What can you do?
We will communicate it to the respondent number 4 or to the RERA authority that this is a clarification that we have received by them, by which there we can act upon it.
Yes, that I'll.
Yes,
that
yes,
I'll
my lord.
record.
Unless until the concurrence by the respondent number 4.
It is a grievance of the petitioner that unilaterally the recovery certificate is issued by the respondent. Next, and it is the submission that they've already paid more than 1 crore 84 lakhs as on today. And
My
during
lord,
the
I
pendency
paid
of
1
the-
crore 85 lakhs, 16,389 rupees, my lord.
You wrote it?
1 crore 85,
lakhs,
16,389 rupees, my lord.
16,389. Land counsel appearing, next para, land counsel appearing for the fourth respondent submits that as per the compromise decree, when he has failed to pay the amounts, they have initiated the recovery certificate was issued and the execution proceedings were initiated. It is submitted that have you accept that he had paid the amount here?
My lord, after filing this writ petition, they are
After
paid.
filing the writ petition, entire amount is paid?
1
Yes.
crore 85 lakhs paid. Up to that interest, only 10 lakhs and not due is there. My lord.
Huh?
My lord, he is calculating
After-
interest on
How
interest.
much? 1 minute, how much he needs to pay now?
My lord, they have to pay as on 13 lakhs 80,815.
It is submitted that as on today, an amount of rupees 13 lakhs and odd is had to be paid by the petitioner. Learned HCGP appearing for the second
AG.
and
AGA.
AG appearing for respondent.
Yes,
My lord, 2 and 3.
Respondents 2 and 3 submits that while the notice is issued to the petitioner on 23/9/2021.
Yes.
On 23/9/2021, asking him whether the such amount is paid or not. If not, he has to pay the amount. He should have come to the authority and ought to have replied to ought to have submitted himself before the authorities, so that if any clarification is required, they would have sought the clarification from the first respondent. But unfortunately, the petitioner, without approaching the third respondent, has filed this writ petition and is litigating the matter from the year 2022 till now. It is submitted that This is a abuse of process of the court. Next para, having heard the counsels on either side, peruse the material on record. The parties have entered into a compromise before the RERA Appellate Tribunal on
My lord,
23/12/2020.
23/12/2020, as per the same. The petitioner was directed to pay an amount of rupees 1 crore
75 lakhs.
1 crore 75 lakhs. Out of that, an amount of rupees
54 lakhs.
55 lakhs 24,000.
Yes, ma'am.
24,000, which is lying in the, before the appellate authority. The petitioner was permitted to withdraw. A timeline was fixed for payment of the remaining amounts. When according to the fourth respondent, when the same was not filed, he has obtained the recovery certificate from the first respondent and all has approached the third respondent. It is the case of the petitioner that now the recovery certificate that is issued is the figures that are mentioned are not the same as they are in the compromise memo, and the interest and other components are added, and no notice was given to him. This the third respondent has issued a notice to the petitioner on 23/9/2021. Petitioner, instead of replying to the same, has come before this court by filing the instant petition on 15/2/2022. 2022. Several contentions are raised on behalf of the petitioner. It is stated that the entire amount is paid. And the counsel is submitting about, yes.
Before that, before approaching this court, I had approached RERA Tribunal Chairman on 20/12/2021 Annexure M, wherein I had said
That he has approached the RERA again. When the execution proceedings were initiated, when a notice he has received from the respondent, Tehsildar, the petitioner ought to have approached the Tehsildar by submitting, by giving a suitable reply to the notice stated. Instead of that, he has come before the court right from 22 till 2026. The matter is pending before the court. Now, with regard to the payment that is made, both the petitioner and the respondents are submitting. They have their own contentions. According to the petitioner, he has paid the entire amount. According to the fourth respondent, an amount of rupees 13 lakhs and odd is still pending.
80,859.
80,000?
13 lakhs 80,859.
59 is still outstanding. This court exercises jurisdiction under Article 226 of the Constitution of India. Cannot go into these disputed questions of fact. As this matter is pending before as the Tehsildar has issued the notice, and in fact it is stated that when there was no amount paid, a attachment arrest warrant was also issued. Considering all these aspects, this court is passing the following order. The respondent, the petitioner shall approach the third respondent and shall appear before him on 12th of March by 12th of March, and the third by a suitable reply, and also third respondent shall consider the same and and if necessary shall seek necessary clarification from the appellate authority. All this exercise shall be completed within 4 weeks from, what is the date I said, 15th?
12th March, my lord, you said.
12th, from 12th, within 1 month, the whole exercise shall be completed.
I may also begin opposite to
Huh?
few calculations.
On the same day, on the 12th, even the respondent shall appear before the Tehsildar and shall give his calculation memo also.
Notice may be dispensed because the parties are before this honorable court.
Huh?
Notice may be dispensed because parties are already.
No further notice is required as both the parties, as this is, because that itself is evident, no further notice is required. Yes, next.
Much obliged, my lord.
With your lordship's kind leave, serial number 30, I may be permitted to withdraw.
Take that. Serial number 30, dismissed as withdrawn. Yes, 35.
35. But Ganapati Narayan,
In this case, my lord, limited prayer, my lord, that we have sought certain information from the first respondent regarding formation of road. By making
Please
several,
come to the prayer.
please, my lord,
Come to the prayer.
prayer, my lord, kindly.
Yes.
In
Page
page
number?
number, my lord, 10. Issue writ of mandamus or appropriate or direct the first respondent to provide information to the petitioner. as-
How can there be a writ against it?
I'll make, kindly see annexure C, my lord, for a moment. Annexure C.
No. You have asked the right to commissioner, right to information.
Yes,
And there was a direction.
yes.
If that direction is not complied with, what is the action under the right to information?
Right to information act, my lord, that once again that we have to approach commissioner, and my lord, once it is disposed of contempt proceedings, they can't initiate. Therefore, this matter has itself is disposed of. Kindly see in page number 45 for a moment, my lord. 45 annexure C.
No. Right to information act.
Yes,
This
yes,
is the right to
kindly see.
information act. No, in a way, court is executing that order now. Passed by the right to right to.
They have
commission,
not
right to
provided.
information.
I am seeking writ of mandamus directing to implement this order.
We'll see what is the provision that is
Please,
available
please,
under
please,
that.
please.
Yes. What is the provision?
Section 20, my lord. That is 19 power of function of commission, 19 appeal, and 20 penalties.
No. Who has passed this order?
This is, my lord, passed order by the Karnataka Information Commission.
Yes.
Karnataka Information Commission has been filed, passed order directing them.
So now
to
there is no question of appeal to you because your
Yes.
grievance is reduced.
reduce. Yes.
Then
My lord, penalties he has to, my lord, impose, but my lord, this matter disposed of directly.
the Central Information Commission has stated as the case may. Please read that 20 penalties.
Penalty, yes. Yes. Where the Central Information Commission, the State Information Commission, as case may be, at the time of deciding any complaint or appeal is of the opinion that Central Public Information Officer or the State Public Information Officer, as case may be, has without any reasonable cause refused to receive an application for information or has not furnished information within specified under section 1 of section 7 of malafidely denied the request of the information or knowledge given which was subject of the request of the obstructed in any manner in furnishing the information, it shall impose penalty of 250 rupees and each day till application is received information is furnished. So however, the total amount such penalty shall not be exceed 25,000 rupees, provided that Central Public Information Officer or State Public Information Officer, as case may be, shall give reasonable opportunity to being heard before penalty is imposed. Provided further that the burden of proving that they acted responsibility and
What is
diligence.
23?
23, my lord, bar jurisdiction of the court. No court shall entertain the suit, application, or the proceedings in respect of any order made under this act. No such order shall be called in question otherwise than way of an appeal under this act. This is, my lord, that I am not questioning the order passed by the commission. I am seeking, my lord, this is, my lord,
What did you do after this?
after this, my lord, that I have proved. This order came to be passed in the year of 2021. I keep on approaching and several applications which we have given to furnish the information. Information has not been given. Why they are not informing? That's all, my lord, that they have to submit.
Yes.
State is not a party. State is not a party.
State is not a part.
No, it's a private list.
Panchayat.
Panchayat. It's represented by their
Public-
own advocates.
That
State
is
is not a
Gram
party.
Panchayat.
It's a Gram Panchayat where they have a panel advocates.
Panel advocates that.
And the notice is not served to them so far.
Notice is not even order.
Notice has been served.
Gram Panchayat, who represents?
There is some local panel advocates. will be
Panel
there.
advocate.
Who is the panel advocate? Chitradurga.
Chitrapur.
Find out.
Find, your lordship may kindly direct to serve the notice on the council who is appearing.
Then counsel for the petition serve the copy of the writ petition on R1,
Panel advocate, panel council.
1 and 2 are one and same
Yes, yes, yes.
on
Okay.
respondent and shall file a memo to that effect. Once a memo is filed, this is matter.
Please,
Yes, next.
36,
grateful.
Chirahulli, Dildar. 36,
36, my lordship, eviction notice is issued on the ground that the land where they have constructed the house belongs to the government property.
Let's see.
Yes, my lord.
To quash a notice issued with the fourth respondent.
Yes, your lordship will get
What
it
is their
paid.
case?
Their case is that there is a private land.
And have they filed any document in support of that?
No, my lordship.
List no representation, list this matter for dismissal tomorrow. Yes, 37.
37, Chandrasekhar.
The response
Appear for
also
respondent number 2, bank in this matter, my lord.
Huh?
I appear for respondent number 2, bank in this matter, my lord. The writ petition has become infructuous since in the month of January 2024 itself, loan accounts have been closed under OTS by the.
Then counsel according to the respondent bank submits that the writ petition has become infructuous as a loan account is closed in the month of Jan 2024. Considering recording the said submission, the writ petition is dismissed as infructuous. Yes, 38.
38, Ravindra VS.
Not for petitioner. But the prayer, my lord, has been sought.
39.
38.
Prayer has been sought, my lord, for quashing, my lord, the annexure J. But and, my lord, the other, my lord, the mandamus has also been sought. My lord, the annexure J, my lord, what is
So
up,
it
my lord?
was issued quashing the order dated 9/8/2023.
My lord,
Redo the process of verification, consideration and passing of order by doing a draw of lots as per Rule 61B3 of the Karnataka Essential Commodities Act. What is the order?
my lord,
include?
now, my lord, the petitioner, my lord, he is a handicapped, my lord, the person. My lord, a notification came to be filed, called for invite, my lord, the granting, my lord, the allotment of fair shop, my lord, within, my lord, the village itself. My lord, I filed an application. My lord, along with, my lord, under the quota of, my lord, the physically handicapped quota. My lord, since, my lord, along with, my lord, the petitioner, my lord, the 4 applicants is also filed an application. Now, my lord, after, my lord,
Notice
the
is served to
application has
him?
been sought.
Notice is served to him.
My lord, notice has been served. My
lord,
lord,
before
the 5th respondent has been allotted.
He was not eligible as per rule
But I am
5.
permitted to make my submission, my lord, then.
Kindly see rule
Once
5.
Say, let him say what he wants.
Yes.
My lord, now, my lord, my application came to be, my lord, the rejected after lapse of, my lord, 3 years by filing, my lord, the application for seeking for allotment of fair shop. My lord, now, my lord, the order for passed by, my lord, the 4th respondent, my lord, the joint commissioner is that, my lord, as on the date of application, I did not, my lord, furnish, my lord, with respect to, my lord, the rental agreement of Godan and, my lord, the financial capacity of, my lord, to show the, my lord, the account extra. My lord, now, my lord, in the application itself, but I am permitted to read out, my lord, the
Have you produced those two?
but it has been produced. Whatever, my lord, it has been stated in the application. My lord, there is a prescribed format calling for, my lord, for submitting, my lord, the details of, my
For
lord,
the
whatever
counsel for
this.
the petition in part, no representation for the 5th respondent. List this matter as part heard day after tomorrow. Yes.
39, Tikar
I am for respondent number 2, my lord. In this case, I appear for petitioner, my lordship. I'm challenging the order passed by the DRT. The application was filed during COVID period. The sale, entire transaction, everything has done in COVID
So
period.
come before the court instead of going to DRAT.
As if the appellate tribunal dismissed the suit stating 13 days delay. The application filed during COVID period. There are circulars and guidelines given by Supreme Court as well as by the Honorable High Court without considering the guidelines issued.
So where is, when was the essay filed?
That should be covered by judgment of the Honorable Court. In similar circumstances, this court has allowed the writ petition.
My lord, for the respondent, senior is held up with court hall number 20.
Password?
Yeah, please, my lord.
Password.
Much.
Yes.
40 urgent, 41, Saraswati.
The party, my lord, party, my lord.
Yes.
My lord
40.
directed the respondent bank, my earlier order.
40.
40.
40 urgent.
My lord,
40 is adjourned in
please,
the
my
morning.
lord, my lord, what happened? They were not informed of the party, my lord, directed the bank to
When is it going to be listed? It will come. Yes, next 41.
41.
I asked them, they said that it is informed. Then only I've adjourned the matter.
Specific direction of my lord.
You can mention it next time when it comes.
Please.
It will come next week.
I'm sorry, my
Yes,
lord.
yes,
Troubling.
41.
My lord, in this matter, my lord, section 14 order has been challenged.
Hmm. No representation for
My lord,
dismissal tomorrow.
The interim order has been taken, my lord.
Tomorrow.
Much.
Don't extend the interim order, all dismissal matters.
42, Kavita.
My lord, in this matter, my lord, the loan account has been settled. We are permitted to file memo to that effect.
Then counsel appearing for the respondent bank submits that the
And for
loan
the-
account is settled. On what date?
My lord, the loan account has been settled, my lord, during the pendency of this
During
matter.
the pendency of these proceedings, the loan account is settled. The counsel appearing for the respondent bank has filed a memo before this court. Memo is taken on record and the petition is dismissed as infructuous.
Much.
Yes. Yes, next.
43 urgent, 44, Bhagat Venkatesh. Venkatesh or Bhagat?
This case,
Venkatesh.
13 to and 13 for notices are challengeable. That's the prayer manner. I'm not asking for accommodation. As per the interim order, I deposited 50 lakhs. And another interim order, I deposited this month 70 lakhs deposited. Now there is no NPA. But I will go on praying. By end of May, I will pay entire. That's all. No other prayer.
My instruction, my lord, is not, my lord, regularized as of now. In fact, my lord, the position notice SL before this honorable court outstanding is, my lord, more than 5.5 crore. It's a matter of fact, my lord, whatever interim order made by this honorable court, he complied it.
What is the difficulty in regularizing the account?
My instruction, my lord, one is, my lord, earlier also we given opportunity. Second, my lord, we have already filed a suit before the DRT at Bangalore. It is pending for consideration. In this juncture, my lord, we can't, my lord, regularize the account. And my lord, unit is not functioning. That is also my oral instruction. Unit is also not functioning.
Well, my 6 projects are functioning. 100 crores inventory is there, my lord. 100 crores inventory.
You get specific instructions from
Well, in fact, I have an instruction. It says that unit is not functioning. If it is required, I'll keep present the authorized officer tomorrow. My lord,
What
in
has
fact,
happened, my lord?
once
I am
OA
having-
file-
No, please understand. Now we can't compel the bank contrary to their working pattern to do anything.
Yes.
Now they say it's not feasible to regularize the account.
Just one page 82 maybe kindly see.
Yes.
That is the this message given to us at 20th December. SA Enterprises OD number so and so irregular activity is OD account, my lord. Amount plus interest accrued is 45 lakh 55,781. Please pay the total amount of rupees 45 lakh 57 to come out of the NP.
What is the outstanding, what is the loan amount?
My lord, 5 crore 80 lakh 87,812.
Yes, madam. That is up to 2031 it is there, madam. 2031. Just I will take your lordship another page, madam. Yes, for 3 months I was defaulted. Now entire payment is made up to 31st March done, madam.
When was the loan declared as NPA?
September 2025. And December they told pay the amount. 90 days over.
In fact, 13th I issued in the month of October 2025.
Yes, madam.
See, it is 25. Find out. Ultimately, you want the money.
I agree, my lord. My lord, have it tomorrow. I'll take a proper instruction. It is a case, my lord.
Tomorrow, day after.
Any day.
Day after.
Yes.
This is smarter, day after.
Till then stay may be kindly extended.
Stays there.
Yes.
Interim order earlier granted is extended till then.
Great.
Yes.
Yes, 45.
Fine. Sheshgiri Rao.
Proposed challenge was the 14 order. The possession is restored. Prayer B may not will have to be considered for a moment. Notice we have sought for regularization of the account. If the lordship would see the prayer at page 9.
Can such an order be passed?
Notice because I cannot, notice this is a, for this, notice kindly see, I cannot go before the civil court.
No.
Upgradation.
Can the court direct them to regularize?
In terms of, because notice, this is based on the prudential
guidelines issued by the Reserve Bank of India for all banking institutions. There was a non-performing asset. Then, my lords, the overdues are now cleared. What remains, my lords, is regularization of the account.
Look at it. What is the praise you're seeking?
Please, my lords, prayer be, my lords.
One is to quash 14.
Yes, but that is taken care.
Huh?
The possession has been redelivered. Possession stands redelivered. Then, my lords, in terms of prayer 2 for a moment, to direct the respondent to validate the account of the petitioners and issue such to upgrade the loan account from non-performing assets to regular account on receipt of rupees 15 lakhs. So I paid 10 lakhs. I am ready to pay the remaining 15 lakhs.
Can we direct them?
In terms of the RBI guidelines, once the NPA dues are paid up, the account will have to be regularized. That is the guidelines which
If you pay, they will do it.
I have paid them 10 lakhs.
There will be a direction for that.
They don't, if I'm not wrong, the NPS will not be upgraded automatically.
If the Reserve Bank guidelines is to do it, they will do it. If it is not, they will not do it, isn't it?
There are guidelines.
Why should you anticipate that they will not do it? And why should there be a direction by this?
Then, Your Lordship, I have tendered my requisition. Your Lordship may have this next week. If they don't, then I'll precipitate it. Otherwise, it can be withdrawn.
And we will not issue any directions to them.
To that effect, the law
Does
is.
this matter next week?
Please.
Yes.
46. Tantrajappa.
Yes.
For the respondent, Lord, I had filed caveat, my lord, copy is not served. I'm also filing wakalat last.
Let's hear what is that you
Witness
say.
Shastri
Yes, what do you want?
I have challenged the annexure L, my lord. Vacating notice, my lord. The petitioner and respondent bank was settled the matter, my lord. Settled the matter. Annexure, page number 53, annexure G.
I didn't understand. Petitioner?
And respondent bank settled the matter as per OTC. One-time settlement, my lord, dated 14/1/2026. Amount of rupees 9,50,000 on or before 2/2/2026. The petitioner is paid entire loan amount, my lord. Annexure H is 17/1/2026 is 4 lakhs.
Give him papers. Then give him papers.
No, already copy was served on 20.
I have received the copy from Mr.
Look at
Vignesh.
it, Paso.
Your lordship may have it tomorrow, my lord, because they are saying
within
that
7
there
days
is a
is to
settlement.
vacate the position. The entire amount
7
was
days
paid.
means how many days are left for you?
2 days, 4 days is.
Your lordship may have it tomorrow, my lord.
Yes, tomorrow.
Undertake to vacate, not vacate.
Why should we pass that order when you have enough time? We'll hear it tomorrow.
Tomorrow, your lordship.
Yes.
My lord, my name may kindly be shown.
Yes, so and so. For the respondent.
Please.
As filed Wakalat.
Nandishwar.
Nandish.
Yes, next.
47 Arjun. 48. Pratima SP.
The respondent has not been coming in this matter at all. For the past few hearings, they're not there.
Yes, what is this matter about?
Plus, this is regarding the maintenance that was awarded to the respondent, 20,000, on the premise that his bank statements are showing more, which is a false stimulus.
Court has granted 20,000. What is your
20,000.
what is your income?
At the time of filing the affidavit, he had lost his job. He was getting interest from the bank, which is reflected in the bank. Plus, he created 25 lakhs in the FD. Now the court takes it as cumulative that was renewed every year. Instead of 25
How
lakhs,
much interest you would get on 25 lakhs?
13,000. 13,000 per month.
On 25 lakhs?
25 lakhs.
And why is he not working?
He is not able to get job. Now he's having odd jobs he's doing, but that he earns about 5,000, 10,000.
So how much should be the maintenance?
Maintenance is 20,000 is awarded. She did not come at all. She is refusing to join. She herself on the first appearance, the advocate had said that
How
she's.
much you are suggesting?
Lots.
How much should be the maintenance? How much your client is ready?
I leave it to your lordship. Lots. She is staying with her parents, whereas she is quoted 35,000 monthly expenses
We'll
on the.
make it
She is an
10,000.
MSc graduate holder.
We'll make it 10,000.
Please, Millards, whatever you
Please go. The present petition is filed. Agreed with the order passed in. Where is the order?
Plus at page 7, operative portion is at 72. It starts at Millard's 69.
Agreed with the order passed in IN number 4 in MC number 2726 of 2021, dated 21st March 2024. The husband is before this court. Parties are referred to as wife and husband for the sake of convenience. The respondent wife has filed IN number 4 seeking maintenance of an amount of rupees 35,000 per month. It is a case of the wife that she is unemployed and she has no source of income. Petition is having two sources of income and working at the company and getting at rupees 1 lakh per month from all the sources. It is a case of the husband that he lost his job due to COVID-19 and is unemployed and unable to take up any employment. The respondent is qualified in working in digital data. The housewife is qualified in working in digital data service as DEO since 28/4/2021 and getting salary of more than 50,000 and capable of maintaining herself. The court, by order impugned, granted an amount of rupees 20,000 per month to the wife. While granting the maintenance, the court has observed that the wife has produced a bank account statement wherein she had only rupees 1,05,001 as on 19/12/2022. The husband in the affidavit of assets and liabilities shown his qualification as BE in computer and income is shown as 13,000 per month. The husband had filed the IT returns from 2014 to 15 to 2022. In the year 2018-19, his gross income was rupees 2,47,249. The bank statement discloses that from 2018, balance is maintained at rupees 50,000 and odd. In the year 2020, rupees 26,10,408 was credited to his account, and it was transferred to another account out of rupees 25,70,000. The petitioner is having a sweep transfer, and as on 7/12/2020, he had rupees 78,80,890 amount in his account. The bank statement discloses that as on 5/7/2022, he was holding rupees 1,06,97,429. The court has come to the conclusion that the account statement is enough to hold that he is having income of sufficient income, and the court had granted an amount of rupees 20,000 as maintenance. When counsel appearing for the petitioner husband submits that the court, without any basis, has come to the conclusion that there is 1 crore and odd deposits in the bank account. It is submitted that an amount of rupees 25 lakhs that is deposited in the bank, he is getting a interest of 13,000 per month. Apart from that, he is not having any other income.
Respondent.
Where are you? It's not today. You have not come for 7-8 occasions. Why you are not appearing?
5 minutes late.
Yes, what do you say?
Pending ಇದೆ my lord.
Huh?
Pending ಇದೆ maintenance. Magistrate court ಅಲ್ಲಿ ಮತ್ತೆ 498A ಆಮೇಲೆ MC ಕೇಸ್ ಎಲ್ಲ pending ಇದೆ ಮೇಲೆ.
Speak in English.
No, what I'm saying is what is your submission with regard to the order impugned? Court has granted 20,000. According to the petitioner, the husband is unemployed.
Okay.
And the amount of 20,000 that is granted is on the higher side. What do you say?
ತುಂಬಾ ಲೋ ಇದೆ ಸಮಯ. ತುಂಬಾ ಪೂರ್ ಇದ್ದಾರೆ. ಈಗ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪೂರ್ ಇದ್ದಾರೆ.
Submit in English.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಪೂರ್.
Password.
Password.
Password. I'll continue from there. Whoever is coming in the afternoon. Yes.
49. Chiddappa.
Hearing for petition.
Yes. Where is affidavit?
I have filed affidavit on 26.
Have you seen that affidavit?
Lord, they given an affidavit saying that from today 1 year, my lord, kindly see the order dated 14/1/2026 passed by this honorable. Subsequently, my lord, 19/8, 19/1, then 30th one and 24/2. On that day, my lord, on 14/1, they supposed to file an affidavit for a period of 4 weeks. Today they are filing an affidavit saying that they need 1 year from today.
Court will not grant, let them file whatever affidavit. If you
When-
file an affidavit, listen to the court. If you file an affidavit, you are ready to pay within 4 months, it's fine.
Even
Otherwise, I'll pass orders on the merits of the matter.
Even my lord, 4 week month also, my lord, I have some objection. The reason is this: 2014, my lord, 24, my lord, interim order granted. My lord, thereafter nothing, not paid anything towards the, except my lord saying before the court, I am going to settle. This honorable court given, my lord, 4 occasions, my lord, this honorable court given opportunity to say that file an affidavit. They are not filed.
Let him complete.
My lord, therefore, my lord,
What is
this
saying, let
stay
him
should-
complete.
My lord, therefore, my lord, I am strongly objecting for a, my lord, extension of stay in this matter.
First of all, I humbly accept that I took 8 weeks before lordship. It is a very, during the, in my affidavit, I have said that the construction.
I will not grant 1 year time. Whatever is the reason.
That is a minority institution where all all children from all poor and unstable are studying there. According to my client instructions only, I had submitted before the court. Now he has only put the affidavit seeking 1 year. If your lordship doesn't want 1 year, at least grant 6 months time. And he has got all my original documents.
Outstanding amount.
And in one writ petition, he has settled 2 crores. 2 crores he has settled. Another 1 crore is there. 77 lakhs is there. I am not arguing on anything. My humble request before your lordship is, it is a minority institution. No profit is earning from that. All students of minority, like under downtrodden people, such are studying.
Might be that we cannot consider. And
No, I am not. Only thing
Madam,
my submission before the humble lordship is, I am not asking to reduce amount. I am giving interest also. I am seeking extra time. That's all. That's all.
grant the time, please understand, not 1 year.
I'll point out his own undertaking before this honorable court on my lord 14-1. My lord, my friend said 4 weeks may be granted. My lord, I'll just read the order. Learn counsel.
I am agreeing, your lordship. I am not saying that I am not at all disagreeing. Before I am straight away, honestly, I am submitting 8 weeks time ahead on instructions.
You can't, you can't have this.
14-1, maximum 14-2. That my lord, their own undertaking is gone now. 14
And
I'll just read
my humble submission before your lordship is, whenever they take some money, they are not depositing. They are insisting 77 lakhs to be paid on a single shot. How can we pay 77 lakhs? It's a charitable institution. Before taking loan only, they were told it. And one-time settlement, they have again shot a letter. They are not agreeing for one-time
counsel for
settlement
the
also.
respondent submits that the outstanding is 77 lakh. Learn counsel for the petitioner submits that he is ready to pay the entire amount within.
Only I am requesting your lordship.
Please wait, that is not the way you argue. When he's submitting, you have to hear him.
Learn counsel for the petitioner submits that he is ready to pay the entire amount within a period of 8 weeks, and they will file an undertaking affidavit before this court. Least a matter on 19-1-2026. This is ordered on 14-1. That 8 weeks also gone.
This is happening from 14-1.
14-1. Then, my lord, this honorable court adjourned the matter to my lord on 19-1. The matter 19-1, the matter didn't reach, maybe my lord, the reason. 30th one, again matter got tested. Again, he said the same thing. I'll file an affidavit. This honorable court recorded. Then, my lord, on 24-2-2026, this honorable court last opportunity has been given. No, my lord is coming and saying that, my lord, in 1 year time, it can't be acceptable. 2024 on from 2024 interim orders, my lord, in operation.
Yes.
Madam, the loan has been taken in 21. 2 years COVID period. The government of India only has taken that. Don't proceed against, and the interest also give them some time. When then all they are paying. They are not adhering. And one writ petition already they have proved they are genuine party. There are 2 crores they have settled. I am only praying before your lordship for not 1 year. Your lordship may grant 6 months. That's all. It's a minority institution. No profit is there, madam. What 30 to 50 children are studying, and staff is also working on morality grounds. If your lordship may grant another 6 months, I am requesting before your lordship. That's all, your lordship. Nothing is.
So only your submission of 4 weeks. On that, I have adjourned this matter. Otherwise, on the first day itself, I would have dismissed this petition.
My lord, about to dismiss the matter on that day, they given an undertaking before this honorable court.
The writ petition is filed, seeking the following prayer. On the last, when this matter came up before this court, on 14/1/2026, when this court wanted to dismiss the writ petition as the same is not maintainable before this court, the petition has to avail the alternative remedy. A submission is made that the Outstanding amount as on today is rupees
77,67,000
77,67,310.
as on 14 January.
And the petition is ready to pay the entire amount within a period of 8 weeks, and they'll file an undertaking affidavit before this court. Accordingly, the matter was directed to be listed as part heard on 19/1/2026. Then the matter came up on 31/1996. Again, on the day, the court has passed an order that if the undertaking affidavit is not filed by the next date of hearing, the petition will be decided on the merits of the matter. Then again, on 24/2/2026, again, the petitioner has sought for time, and the matter was directed to be listed on 3/3/2026. When this matter is listed before the court today, it is submitted that an undertaking affidavit is filed, and they are seeking, the petitioner seeks a 1 year time to pay the amount. It is submitted that it is a minority institution, no profit organization, and if the time is not granted, it will cause a lot of hardship to the petitioners as well as to the students who are studying in the said institution. Next parallel, and counsel appearing for the respondent submits that, basing on the request that he is ready to pay the amount, this court from time to time adjourn the matter, and the court, it is not acceptable for the bank, acceptable to the bank, and 1 year of time is not entitled. It is submitted that the petition has an effective alternative remedy. On that ground, the writ petition has to be dismissed. Next part. Having heard the counsels on either side, there is a material on record. In this case, the petitioner has questioned a position notice. When the position notice is issued to the respondent, the remedy available to him is not before this court. That is issued under section 13(4).
Please, Madam.
The petition, the remedy is not, the petitioner has no remedy before this court. When the proceedings are initiated in the Surface Act, the person who is agreed with the same has to approach the DRT, where the tribunal is deciding the disputes between the parties in a more efficient manner. And the Honorable Apex Court has time and again has deprecated the practice of the High Courts interfering with the surface proceedings. If the petitioner had come up with an undertaking that he is ready to pay the amount within 4 weeks, as stated before this court would have accommodated the petitioner. But the affidavit that is filed before the court seeking 1 year time, this court cannot grant a year's time for paying the amount. In that view of the matter, this court do not find any reasons to interfere. Accordingly, this court is passing the following order. The petition is disposed of, giving liberty to the petitioner to avail the alternative remedies, if any, in accordance with law. Accordingly, disposed of. This for 50.
Read from
50. Initiative.
Some settlement is going on. Week time may be granted. The borrower is given a representation to the bank. It will close the entire loan
What
account.
about the core issue to be decided?
Because the core issue is that right now the bank is playing a dual role here.
No, that's what, whether the bank can buy the property.
Bank can buy the property, that is not in dispute. Now sales certificate is not registered. Now the issue is I am an auction purchaser as well as I am a secured creditor. I am playing dual roles here. If the borrower has told that anyhow I am going to pay the entire loan dues.
What do you say, Mr. Vignesh?
My lord, in this matter, I am inviting some order from this honorable. The reason is this: when I filed an application before the DRT, reveal who is auction purchaser. My lord, with the great hurriedly, DRT passed an order saying that, my lord, sale is, my lord, correct. My lord, I'll just point out, my lord, 2 dates. First and foremost, in this matter, bank cannot purchase a property in view of section 8.
That's what is your submission.
That's what my submission. In fact, it is
That's
recorded.
what I have recorded that.
Recorded that. First and foremost, my lord, they can't purchase a property in the first instance. Second submission,
Yes, they can.
No, they can't. That is the case, my lord. I'm ready with my submissions. I have, my lord, authorities which I placed before this honorable court. I'm ready with my submissions.
One date may be given, my lord, so I'll make 2 after 2.
When do you want?
Any date after 2 weeks.
But some interim order. In fact, this honorable court said that, in fact, recorded, my lord, detailed order. In fact, my lord, this honorable court held, this honorable court have a jurisdiction to pass an order. My lord, in fact, they are not filed any appeal according to me and no notice served upon me. Some interim order may be.
He says an appeal is filed.
Appeal is filed.
They're not bringing on board, my lord. And
Then
no
what happened
state-
to that appeal?
It's coming next week. We have made a present. We have moved a memo. It's coming. Only thing is, in the appeal, I am only on the one fact that this court told if fraud is alleged, this court can entertain writ petition under Article 226. Here, the question of clever drafting has also arisen only for the squeezing in the element of fraud. The clever, that is also there. So that's only on that factor. I'm before the Honorable Division Bench, my lords. 2 weeks time may be granted.
He is aware of the result of the writ appeal, but we will accommodate him when.
After 2 weeks.
Does this matter on 18th March?
If my learned friend is insisting on interim order, let status quo may be granted, because in fact, Lordship told me to file a separate application to that text, as I am the respondent here. He is continuing construction in spite of the matter is settled before this court. He is putting up apartment there. If apartments are sold to third parties.
So you think status quo order is order in your favor or his favor?
Then both of them, let there be a status quo with respect of the property, where the property.
Decide the matter itself.
Published.
Yes, next.
Passed over
Any
cases.
passed over matters?
Passed over cases. Number 13. Ichikesh Joshi.
Make the entire list for all 7 cases.
Appearing for respondent number 4.
Take that.
Yes, please.
Entire 7 cases.
Yes.
Please come. Now, in all these matters, who are appearing, all their names to be recorded.
My lord.
And shall be along with writ petition number, that also?
I've written it at the top, my lord. 5667 of 25.
My lord, undertake to appear, Divya Purandar, respondent number 4.
Respondent number 4, where Vignesh Shetty's name is.
They served a copy upon me.
So wherever Vignesh Shetty's name, for respondent 4 and 7.
Only 4.
7 you appear.
No, no.
I have some conflict in this matter. I'll send the file to bank. They served a copy upon to my office. In fact, already I sent a mail to bank saying that I have a conflict.
So as far as Divya Purandar is concerned,
State Bank of
it is only 4 you are saying in all the matters.
Please,
Except 13.2 and 13.6. SBI is not a party.
So 13.2 and 13.6, respondent number 4. Divya,
My lord, 13, 13.1, 13.3.
you please write where you are appearing. Give it to him. And accordingly, and post along with the batch. Yes, next.
My lord,
If
interim
you have
order.
any doubt, please ask. Yes.
Interim order may kindly be extended in the.
Interim order earlier granted is extended till the next date of hearing. Yes.
Much obliged.
16.
I make sure appear on behalf of KVT in this matter.
Manoj.
Lords, this is the second writ petition. Lords, there was a section 13(2) notice issued in the month of June 2023. Lords, that was challenged by filing the first writ petition, that is WP number 6302 of 2026.
So you are saying that
WP number 18808 of 2023.
classing the account of petition as NPA is
Yes.
bad in law.
Lords, 2023 itself, the petition was before the court when the first NPA was declared, saying that we are entitled to the benefits under the circulars of the RBI, and without extending that, they should not treat this as an NPA. But what the bank had done was, the bank had miscalculated the EMIs paid, and as on the date when the first NPA was declared, there was in fact no NPA. So what they did, they have foregone that first NPA notice, issued the second NPA notice. Again, we gave a reply saying that these are all the benefits which is accrued to us, therefore you should not do it. Between this period, the bank says, all right, we realize that you are an MSME. What we will do is, this 2 years interest which is accumulated, I will spread it for the full term. My full term is in respect of 4 loans. One is in the year 2027 and the other one is up to 2020. If it was spread for the full term, there would have been an escalation of my payable interest by around 2.5 lakhs. This is the communication given to us. After communicating this, when they are giving us the schedule for the payment of the EMIs, they restrict it for 18 months. As a result of which there is a boosting of the interest by around 30 lakhs. Then we again went back to the bank and said it is not possible. RBI says you will have to look into my business pattern. I have never defaulted except for this period of COVID. If you extend this COVID period and the other moratorium which is applicable and the restructuring as permitted under the RBI circular, considering my business, because I am still running the business, there is no way I will be in a position to pay this 32. You had yourself promised that you will have to spread it for the full term. Spread it for full time, I am willing to pay it. But notwithstanding, they again issue a notice in the month of August saying that no, we are calculating this for 18 months. You are not paying this and therefore we are treating this as an NPA. This is
Then you
essentially
reply
where,
to them.
pardon me, lords.
Then you reply to them for the.
Lords, yes, we have given the reply saying that yes, I'm
And
entitled.
what is their reply to that?
Lords, for that there is no reply.
But they have. You have to
13
give a
3A there is
reply.
no reply.
Yes.
It's not, I'll just point it out.
No, 13.2, when you have issued the notice,
Please.
they have given their reply, then you are
So, my lord,
supposed to
here,
respond to that.
my lord, I have to take instruction on that. My lord, kindly see, there is no seal, no, my lord, postal receipt, no acknowledgement, nothing whatsoever, my lord, which there.
Now, let's see, when you say that you have issued a reply to them, where is that reply?
Apart from that.
Page number 81, if your lords were to kindly have a look at page 81, annexure M. They have already committed that we are extending the benefit to you. They took the decision, but practically and physically they did not do it.
No, the latest 13.2 after that.
After 13.2, my lords, the reply
Where is
is
the-
at page number 127.
120?
7. Para 7 and para 8. And we say, as per the guidelines, what we are entitled to in the succeeding paragraphs.
No, how did you send it to the bank? And where is the acknowledgement?
Bank again. We have sent it by both mail and post. That postal receipts or the mail, we will produce it, no difficulty. If that's a stand to be taken, they should have taken instructions before such a statement was made as to whether we have given this reply. That's
Yes,
not.
Mr. Vignesh, to get instructions.
My lord, I'll take instruction. Before that, my lord, I would like to point out two aspects.
No.
If he wants to
One
take
minute.
instructions.
If you get it, no, unless a 13.2, no, that their reply to 13.2 is not considered by you, that itself will be a ground to
Kindly
set
pass it
aside
over.
everything.
Kindly pass it over on this aspect, my lord, I'll take in, my lord, why, my lord, I'm making a submission before this honorable court saying that I have to make 2 points. One is, my lord, earlier rounds of litigation, when they came before this honorable court, my lord, kindly see, my lord, I'll just produce the interim order passed by this honorable court. Their own undertaking before this honorable court, my lord, their own undertaking said that I wanted to pay the entire money. My lord, kindly see the order dated, my lord, 5/1/2024. Lord, they admitted their liability, my lord, 5/1/2024. Learned counsel for the petition submit that petition is ready to regularize their account by paying the dues as on this day. Learned counsel for the respondent bank seeks 1 week time secure instructions. My lord, next date, my lord, on 12/1/2024, this honorable court granted an interim order. Learned counsel for the petition submitted because of the delay of close 12 hours, the account slipped into become NPA and due has expired since then. Up to August 2000, it has the indication of the bank that the amount up to 67 lakh. Therefore, the loan counsel of the petition undertakes to deposit 67 lakh to the bank within 4 weeks from today, failing which the bank is at liberty to take the action in accordance with the law. And fourth, my lord, on 12/2/2024, my lord, this interim order passed by this honorable. The court on 12/1/2024 had passed the following order. Learned counsel for the petition submit that because of the delay, close 12 hours, the account slipped into become NPA and due has slipped since then. Up to August 2023, it was indication of the bank that the amount of 67 lakh, therefore, the learned counsel of the petition undertakes to deposit 67 lakh to the bank within 4 weeks from today, failing which the bank at liberty to take action according to the law. List of matters students. Learned counsel for the respondent bank submits that not even a rupee has been paid by the petitioner pursuant to the said order. Therefore, the interim order granted on 12/1/2024 stands vacated, reserving liberty to the petitioner to seek its restoration. That is one. Immediately that, my lord, from 2024, the managing director of the petitioner filed an application under section 94 before the, my lord, NCLT Hyderabad. My lord, in view of, my lord, they'll get a benefit of, my lord, kindly see the conduct of the petitioner here. My lord, it's not what my senior counsel said, it is not so here. 1.5 years, my lord, they successfully dragged in view of section 100.
No, what is this? What are these submissions?
Can I say this, my lords? The challenge was to the NPA notice issued in the month of June 2023. The earlier petition.
Not
Lords, I am
about
filing it with a memo.
This 5/1/2024.
That notice itself has been withdrawn by the bank.
This is pertaining not to this writ petition.
Lords, this is pertaining to the demand notice or the NPA, which was undertaken in the month of June 2023. I am just passing on the copy of the writ petition. Can I just persuade my lords? Your lords may kindly have a look at this. Because this notice has already been withdrawn by the bank itself. There is no cause which remains.
No, this writ petition is still pending before this court.
Yes. Lord, this has become infructuous for this reason. Of course, on record it is pending. Lords, may kindly have a look at the writ petition prayer, my lords. At page number 9 is the prayer.
No, what is the submission before the court saying that I will pay the entire
Lords,
outstanding?
now what we said, we will regularize this account. Lords, even now we are making the statement. What they are doing is, if your lords is to have a look at page.
What are the dues as on today?
But 70 crore, sale notice.
Lords, it is not.
How much?
20, page number 27, 15 crore, 22 lakh, 66,060, my lord, 15 crore, 22 lakh, 66,060. My lord, why the present writ is filed before this one, I just point out. NCLT, my lord, I appeared before the NCLT. 1.5 year, my lord, there's an interim moratorium against me, not to push it further. In their own petition, I'm not filed under 95, they filed under 94. They accepted the default before the NCLT. I appeared before the NCLT. I made a submission saying that they're only filing an application to delay my recovery of my dues by way of selling the property. Then NCLT rejected it. My lord, kindly see the order passed by the NCLT, their own petition. Then, my lord, I took a possession. I issued a sale notice. The sale notice has held before this honorable court. My lord, my first and foremost submission is, what is, my lord, why, my lord, they bypass the, my lord, alternate remedy under section 17? What is the special case here? My lord, second case.
I think, my lords, this is a matter which has been dealt with by this honorable court. And so far as NPA is concerned, is a matter which is seized, my lords, under 226. That's essentially the view which is taken by your lordships. My lords, I wanted to clarify this, my lords. It is not the manner in which lordships may kindly have a look at the earlier writ petition, because there is an effort, my lords, to see the earlier writ petition was pertaining to the demand notice which was issued on 1st of July 2023. This was the notice which was issued. Now, after issuance of that notice, money was paid even in the earlier months, which was not calculated by them for the purposes of treating this account as an NPA. They realized that issuance of 1st July 2023 notice is erroneous. So they have foregone any further action pursuant to this 1st July 2023. The prayer which was made in the earlier writ petition, the reason why I am referring to this is, we had come before this honorable court on the first instance when they had issued the first notice was on 1st July 23. They are not extending the benefit under the scheme of the RBI circulars. Please direct them to extend the benefit under the scheme of the RBI circulars. I am more than willing to regularize this account. But the difficulty is, this is what they are doing. Now, pursuant to this, we said that we are ready to regularize the account. They say 67 lakhs, absolutely no basis on which they say that 67 lakhs is due, because grievance itself is, it doesn't come to 67 lakhs. Now, that is the next point. Now, what they did, 1st July 2023, they have already foregone. They are not pursuing. If they make a statement that they are still pursuing 1st July 2023, I will definitely go there. This is not there. This cause is already lapsed. And they have ensured that this is lapsed because they had wrongly treated this account as an NPA. Then they issued the second notice on 22/8/2023. Now, after this 22/8/2023 is issued, on 25/8/2023, the reply is given by us. Once there is a second NPA notice, kindly lordships may have a look at page 119, which is their second NPA notice.
No, you're questioning the sale notice also.
Lords, yes, now sale notice is concerned until
14 must have taken place.
Lords, now what they did was, there were two properties which were given. The manner in which they do it. Lord, there's a brewery. It's a running business. Now, 15 crores, what they say is the amounts due. Lords, under section 13(4), there are measures which can be taken. Now, what is the measure that can be challenged before the DRT? But the point is, if it's a running business which is being run, Lords, what is the best way? Because the bank acts as a trustee. That's what Maria Chemicals case said. You cannot come and shut down the business and thereafter sell this. This is a business which would have sold at more than 15 crores. Now, what they did was, they did not take this property or the business for which the loan was advanced. They threw out the family in the residential property which was given as a collateral security. And now they want to auction this collateral security or the residential property, which would not fetch this money. If they had sold that property, they would have fetched the entire money. Now they want to sell this residential property which will not fetch this. Then what happens? They'll have to again sell that property also. So this is the manner in which they are undertaking
why
the
the
measures.
other property can't be sold?
I don't know, my friend. Sridhar only should answer. According to me, I can sell it. I took the one of the house already. I took the position. That is also in respect of second property.
What about the other property?
Other property, my lord, I put the property for auction. I have my lord, there are few enquiries are there. I hope I will successfully. I'll sell the property. I'll recover some money because 2023 onwards my account become NPA. In view of the NCLT and this court order, my lord, I'm not able to realize my money.
Before proceeding with the residential property, you will.
I put both the property for auction.
Huh?
I put, my lord, kindly come to page number 27.
Both the
property
are put for auction.
Please, my lord.
Only the possession of that property is taken. Residential property is taken. Now what happens, my lords, in every auction sale, an auction purchaser will participate with full rigor if the entire control is with the bank. Otherwise, there is a restriction with the auction purchaser, the manner in which he participates. There may be inquiries the manner in which they carry out the valuation for a running business, what profit is, nothing they will do. They will take the physical valuation of the property for the purpose of sale of this property with the possession still remaining. But even before this exercise is conducted, they want to take over this residential property. Now, all said and done, bank is required to comply with the requirements under law. These are all the only safeguards which is available to the borrower. These are the minimum and mandatory safeguards which is available to the borrower.
Already, section 14 proceedings are initiated.
So far as the residential property is concerned, they have already taken possession.
So that you could have gone to the DRT, and DRT all aspects will be considered.
Now, so far as DRT is concerned, your lordships have taken a view in one of the matters, now, the moment I take a plea, because referring to the Pronit's case and the subsequent judgment, your lordships takes a view that the moment we give a reply that I am entitled to the benefits in the RBI, Pronit says it's mandate. Without that, you cannot proceed at all. What we are requesting them from day one is only this. They acceded to this request. I can understand. They acceded to this request saying that, all right, we will spread it over the entire term. After saying that we will give it to the entire term, they restrict it to 18 months and treat my account as an NPA.
I'll just produce one. My senior is making submission saying that classification NPA can't be go before DRT.
Page 81, your lordship may kindly see.
I'll just point out one judgment before this honorable court. In fact, earlier rounds of some other matter, I relayed this judgment. Kindly come to paragraph number 15. It is not correct. 2022, account become NPA, not even groupie paid, and they gone before the NCLT. They themselves admitted default, and now I should have sale notice so that I will sell the property. They're coming for the honorable court saying, various good. Kindly come to page number paragraph from 15. The Surface Act is complete code in itself, which paragraph 15, 1.5. The Honorable Supreme Court tested whether NPA has to decide by the writ court or before the DRT. The Surface Act is a complete code in itself, which provides a procedure to be followed by the secured creditor, and it's also remedy to aggrieved parties, including the borrower in such circumstances as Sally taken note of the High Court in writ proceedings. There is a discrepancy in the manner classifying the account as NPA, appellant's NPA, or the manner in which property was valued, was auctioned. DRT is vested with the power to set as such auction at the stage after the security invokes the power under section 13 of the Surface Act. In view of the forfeited by the decision of the court in Indian Overseas Bank so held as here and so and so. Paragraph 34, 35, 35, they culled out. I'll just read paragraph 16. We reiterate, the action by the bank under Surface Act is neither unquestionable not treated as sacrosanct under all circumstances, but if there is a discrepancy in the manner the bank has proceeded, it is always open to assail in the forum provided. Paragraph 15 says that even classification of NPA also has to be decided by the DRT, not writ court. And 16 says that if I made any violation, there is a competent forum. Here, I would like to point out two aspects. If they would have not filed an application under section 94, they are not admitted their default. I to understand, maybe some here it is not so. They themselves admitted. I'll produce all the papers before this honorable court. In fact, the order copy I produced. I appeared before the NCLT and I said no because I have to sell the property in the Surface Act. Then, the honorable NCLT.
I really fail to understand.
Even
if I am not a defaulter, I am not entitled to the benefit under the scheme of the 2005 Master Circular. I should be a defaulter. If I am not in a position to pay the money, it is only then the circular comes into force.
The petitioner and MSME or not?
MSME, this honorable court held. There should be, in a earliest round of litigation, there should be representation.
We have said it.
13.2, what was the reply?
That, I'll point out.
That's the crux of the issue. We don't have to go, provided on 13.2 you replied to them. And or in the 13.2 they have not stated about the MSME and the benefits.
No, not written anything.
Let's see the 13.
Page 127, Milords.
127. Yes, let's see that.
This is to the second reply. Lordships will kindly see at paragraph number 1. We are an SME in food and beverage industry. Then para 7. The restructuring of COVID loans were done as per RBI resolution framework. Then para 8. We submit that the bank did not apply RBI norms in restructuring their account, namely, we have said what is that we are entitled to as per this RBI circular. Consequently, subparagraph number 4, the EMI payable post moratorium has shot up to 32 lakhs per month, causing extreme financial stress. The company has since the day it has received the EMI schedule, restructuring to the note.
That's what they asked.
No, I'll just
all what we have been asking.
We must already answer this on this letter. If I received, they are not produced even on postal receipt or acknowledgement. Let me find out whether any notice received. Kindly pass it over. It is not the way.
The statement which they should have made at the first instance.
Tomorrow.
Tomorrow.
Very well.
This is matter tomorrow. When the senior counsel appearing for the petitioner submits that when 13-2 notice is issued, they've issued the reply stating that the petitioner's company is an MSME and they are entitled for the benefits as
The master circular.
as per the master circular issued with the Reserve Bank of India. And when counsel appearing for the respondent submits that the senior counsel submits that there is no reply given by the respondents. When counsel appearing for the respondent submits that though they have filed the a reply purported to have been issued given by them to a notice given by the bank under 13-2, no acknowledgement is filed. It is submitted that you would get specific instructions in this regard, and the counsel for the petitioner also shall place on record the acknowledgement for having sent the notice under 13-2.
Grateful, my lord.
This
Please,
tomorrow.
Grateful.
17. Srikant K.
We'll hear it in the afternoon. Any signatures?
My lord, your lordships had mentioned to me to produce the judgment, my lord. Whether
Afternoon.
it, please.
Yes. Please give it to the court.
I'll give it to the court.
ನಾಳೆಗೆ ಅಲ್ಲ ಬಿ ಗ್ರೂಪ್ ರೀಚ್ ಆಗೋದು ಲೇಟ್ ಅಂತ ತಿಳ್ಕೊಂಡೆ ನಾನು. ಬಿ ಗ್ರೂಪ್ ರೀಚ್ ಆಗೋದು ಲೇಟ್ ಅಂತ ತಿಳ್ಕೊಂಡೆ ಅಷ್ಟು ಬೇರೆ ಕೋರ್ಟ್ನಲ್ಲಿ. ನಾಳೆ ಇದೆಯಲ್ಲ
ಸರ್ ಪಾಸ್ವರ್ಡ್ ಎಷ್ಟಿದೆ?
36.
17 ಅಲ್ಲ ಈಗ ಸೋತರ ಸೋತರ ಎಷ್ಟಿದೆಯಂತೆ?
ಓಕೆ ಓಕೆ ಹೊಸವರ ನಿಮ್ದು ಎಷ್ಟನೇ ಸೀರಿಯಲ್?
ಇಲ್ಲ ಇಲ್ಲ ನಂಗೇನು ಕೇಳಿದ್ರು ಅಷ್ಟೇನೆ. 29 ನೋಡಿ.
7ನೇದು.
ಆದ್ರೆ ಅಲ್ಲಿ 12 ಇದೆ. ನಂದೀಶ್ ಪಟ್ಟ ಅವರು ನಂದೀಶ್ ಗೌಡ ಅವರು
ಎಲ್ಲ ಪೇಪರ್ಸ್ ಎಲ್ಲ ಫೈಲ್ಡ್ ಇನ್ ಕೋರ್ಟ್ ಅಂತ ಹಾಕ್ಬೇಕು ಮೇಡಮ್. ಇದು ಇಟ್ಬಿಡೋದು ಯಾವ ಪಿಟಿಷನ್ ಕಾಪಿ ಕೊಟ್ಟರು ಬೇರೆದು ಕೇಸ್ ಫೈಲ್ಡ್ ಇನ್ ಕೋರ್ಟ್ ಅಂತ ಹಾಕ್ಬಿಡಿ. ಹೀಗೆ ಅದು ಬೇರೆ ಇದು 6302 ಹಾಕೋದು. ಡಿಫೈಲ್ಡ್ ಇನ್ ಕೋರ್ಟ್ ಅಂತ ಹಾಕಿ ಅಲ್ಲ ಈ ಕೇಸೇನೆ 6302 ಅಲ್ಲ ಅದೇ ನಂಬರ್ ಬರ್ತಾರೆ. ಬೇರೆ ಪಿಟಿಷನ್ ಕಾಪಿ ಇದೇನೋ ಒಳಗಡೆ ಇರಬೇಕು. ಫೈಲ್ಡ್ ಇನ್ ಅದನ್ನ ಇದು ನಾವು ಕೊಡ್ಬೇಕು. ಇದಿಷ್ಟೇ ಪಾಸ್. ಶಾರ್ಟ್ ಶೀಟ್ ಅಲ್ಲಿ ಕೊಟ್ರ ತಗೊಂಡ್ರ? ಅವ್ರ ಅಲ್ಲವರು ಇದ್ರಲ್ಲಿ ಫೈಲ್ ಅವ್ರಿಗೆ ಇಬ್ಬರವರಲ್ಲ SMC 30.
ಮಧ್ಯಾಹ್ನಕ್ಕಿದೆಯಾ? ಹಿಂಗೆ ಹೇಳದ ಇಲ್ಲ ತಿರುಗಿಸ್ಬೇಕಾ? ಸರ್ ಇದು ಸರ್ ಇದು ತಿರುಗಿಸಿರೋದು ಹಿಂಗೆ ಇಡದ? ಹಿಂಗೆ ಇಡ್ಲ? ಹಾ ಸರಿ ಹಿಂಗೆ ಇದೆ ಇದು
ಸಿಗ್ನೇಚರ್ ಅಂದ್ಬಿಟ್ರು ಆಗುತ್ತೆ ಸಿಗ್ನೇಚರ್ ಫೈಲ್ಸ್
May I make one submission, my lords? In serial number 16, my lords, the doc acknowledgement with respect to service of the notice is in the house, my lords, which the bank has taken the position. Bank may be, my lords, directed to open the lock, my lords, only to take the acknowledgement.
Which matter? How will I know?
Serial number
what-
16, my lords.
What happened?
My lords, the lordship ordered for to produce acknowledgement, my lords, for the service of the notice. My lords, the service of the note acknowledgement is in the house, my lords, where the bank has taken the position. They may be directed to open the lock, my lords, so that I'll take the acknowledgement from there and produce it tomorrow, my lords. Matter is listed tomorrow. Serial number 16, my lords, it was passed over.
So what can't be achieved directly, now it will be achieved indirectly.
It was only to open
We
the.
will see, we will see what the bank will do.
Please.
Yes, next.
The 17 passed over cases, Lakshmikant.
For the petitioner. The petitioner has pledged the arcanate nearly 4,000 quintal, 4,000 kgs, 4,000 quintals, my lord. Pledged the arcanate under the e-way receipts, my lord, at annexure A to AS E, my lord.
What do you say?
My lord, if my lord should kindly see the orders passed by the tribunal. Those aracanates is a case of fraud. There was a direction by the Dharwad bench to open the aracanates. It is a fraud of nearly 60 crores for 4 bankers.
No, why the matter is is coming up before this bench?
Plus, they have sought for a modification of the orders passed by the tribunal. If my lords were to kindly see, my lords, page number 104. Plus, they had preferred a securitization appeal.
That's true. When the property is situated in Dharwad, when the bank
No, property is situated in Shumaga. It comes before this bench.
Then where is
One of the bankers had gone there in Canara Bank, Dharwad branch, which had lent the loan. The coordinate bench directed to open the warehouse. When they opened the warehouse, they found no stock at all. Only one stock was shown to all the bankers, and fraud was committed. Now, Warehouse Development Authority is also lodged a complaint. If my lords were to kindly see the orders.
So saying that the case was registered against so many people and.
Let's see if my lords were to kindly say page number 68, my lords.
68.
68.
Hmm.
This was an order passed by the coordinate bench pursuant to those orders. All the councils on instructions submits. The warehouse is opened. None of the placed goods were found in the warehouse. If my lords were to kindly get, in which bank had also filed a writ petition asking for the opening of the warehouse, because the warehouse was not even opened at all. And subsequently, when the coordinate bench directed to open the warehouse, my lords, none of the goods were found. It was an entire case of fraud. And there have been, and till today, my lords, the borrower has not filed a complaint against the warehouse.
Against the?
Warehouse. Till today, he has not filed.
Then again, it's to be filed.
He has not filed. He has gone and filed a consumer court against the warehouse and the bank. And my lords, they had challenged the securitization appeal. If my lords are to kindly take page number 84. This was an order passed on 16/12/2025.
84.
84, my lords. This was an order passed in 16/12/2025 in SA 468. The measures taken by the respondent bank leading to procurement of section 14 order is under challenge by the applicant. Counsel for the applicant points out that initial liability was about 12 crores. Applicant managed to reduce the liability, and present level as on outstanding amount of 10/12/2026 is 4.66 crores. Even today, my lords, it is 4.66 crores. Hence, according to the counsel for the applicant, the above fact indicates the bona fides of the applicants in his efforts to close the liability. Counsel who entered appearance for the respondent bank on caveat that there is a case of misappropriation of hypothecation in this matter, which indicates a clear case of fraud. Taking note of the rival contention, tribunal has the view since the applicant made a substantial remittance, the following order is passed. Hence, all further proceedings initiated by the respondent as against the scheduled properties will stand stayed till next date of posting on condition that applicant make following remittance. An amount of 30 lakhs is to be paid on or before 30/12/2025, and further amount of 1 crore 27.
Why have you come to this court on 24/2?
And they filed, may I explain? They filed an application for, they remitted an application was filed even before 30/12. Since that application did not come up before the court, 30/12 remittance they made. That application came up before the tribunal subsequently in the first week of January. Tribunal said there's no other grounds, so they rejected the application. Against which they came before this honorable court in page number 86. in page number 86. The operative portion, my lords, could kindly get it at page number 94. The writ petition is disposed of, directing tribunal to consider the application for extension of time filed by the petitioners, pass an appropriate orders within 1 week. Well, subsequently, my lords, they filed an application at page number 95. Page number 95. And they filed an affidavit, my lords, at page number 100, my lords, undertaking affidavit, which they now allege that tribunal insisted to file, so we filed. Plus, making an allegations after obtaining the order, but the answer of tribunal would be unjust. If my lords were to kindly see, para 5 of that page number 100.
Yes.
I submit that presently undertaking this affidavit, making payment in compliance of the interim order, second installment of rupees 40 lakhs and third installment of rupees 40 lakhs, totally amount of 80 lakhs before 27/2/2026, and also fourth installment of 40 lakhs before 33/2026, without seeking any further extension of time for complying of the interim orders passed by this. As per the undertaking, the tribunal passed an order at 104. Applicant is seeking, they were seeking to extend the time which was fixed on 31 for payment. 30th of January, they had to pay 40 lakhs. That was extended. Applicant is seeking extension of time for payment of second limb of condition imposed by this tribunal, which mandates to pay the amount of 40 lakhs on or before 30th of January 2026. Today, a matter is taken up. Learned counsel for the applicant has filed an affidavit stating that third and fourth limb of the conditions will be complied on due dates without seeking any further extension. Based on the above said undertaking, applicant seeks extension of time for payment of second limb of the condition till 27/2/2026. In view of the fact that applicant has filed an affidavit, this tribunal feels that same can be accepted for time for payment of 40 lakhs as directed to be paid on or before 31/2026, stand extended to 27/2/2026, and payment is to be remitted along with third limb. This second limb payment is also not been done till today, Malad. Third limb payment is also not been done. Against this order, they have come before this one.
Milord, my first submission is that, Milord, I have filed a complaint against the bank.
What way the bank and securitization proceedings are concerned?
Please, Milord, may kindly see,
Complaint
Milord.
is not consumer complaint.
Not,
If according to, where is the criminal complaint?
Milord, may kindly see, Milord, page 63, Milord. Page 63, which is, Milord, I have filed a complaint that the petitioner is the petition before the Sarnapa court, Milord, seeking necessary direction against the bank as well as the warehouse, Milord.
How the bank is concerned with that?
Because, Milord, entire goods, Milord, pledged under this instruction only, Milord. They, Milord.
No, I'm not
make
convinced. I'm not convinced. This is pure abuse of process. What you're coming before the court, getting one order from the tribunal, DRT, again coming there, saying that DRT asked me to file an affidavit. That's why tomorrow we'll go to the Supreme Court and say, High Court asked you to file an affidavit.
May kindly see, my application may kindly see, page number 95, Milord.
Comply with the order.
In that, Milord, may kindly.
Comply with the order.
May kindly see, may kindly, Your Honor.
I don't find any grounds. The
Please,
present petition is filed.
page 98, Milord. In the application itself, Milord, I have sought time, Milord, 5 to 8 months time, Milord.
Why will the court grant 5 to 8 months time?
Because, Milord, the entire fraud based on the warehouse as well as
the writ petition is filed, seeking the following prayer.
8 crores you have already deposited.
It is it is a case of the appellant that the court has not granted. No, the facts of the case are the petition has availed the petition has purchased the areca nut from 5 lots.
He had pledged the areca nuts of 5 lots.
And
to
after
the warehouse.
purchasing the said goods, same has been stored in the respondent number 2 warehouse, and by pledging the same, he has availed the loan facility from the respondent bank,
12 crores.
an amount of rupees 12 crores. When the account has become NPA, and when the bank has initiated the proceedings under the Surface Act, the petition has approached the DRT by filing.
SA 468 of 2025.
In which paragraph you said so?
No, it's page number 84, Manoj.
No, in the petition.
Plus grounds, para number 20, my lords, para 17. Para 17, page 12. Page 12, my lords, SA 468 of 2025.
After receiving the notice under section 13(2), petition has issued a reply to the same. Having agreed with the inaction of the respondents, petitioner has approved this court by filing WP number 15044 of 2025. The same was disposed of by giving liberty to approach the appropriate forum for the redressal of his grievance. The petitioner, as per the orders of the court, he has approached the consumer forum and filed the complaint on both the respondents herein under section 35 of the Consumer Protection Act. It is a grievance of the petitioner that the respondent, when bank, without giving the breathing time to the petitioner, had filed an application under section 14 of the Surface Act before the principal senior civil judge in CJM Shimoga. And the court has passed an order under section 14 of the Surface Act dated 21/11/2025. Then the respondent bank issued the vacate notice dated 10/12/2025. Thereafter, the petitioner has approached the DRT by filing essay number 468 of 2025. Then an order was passed on 16/12/2025. Where is that order?
Plus page number 84, my lords.
By staying the proceedings on the condition that an amount of rupees 30 lakhs to be paid on or before 30/12/2025 and a further amount of rupees 1 crore 20 lakhs in 3 installments, that is 40 lakhs each, first of which is to be paid on or before 31/2026, subsequent installments on 29/2/2026 and 30/3/2026, and accordingly passed an order. And also it is observed that failure of compliance of any of the conditions will render vacation of the interim order automatically. Thereafter, the petitioner has difficulty in arranging the amount. Since the goods of the petitioner pledged by the respondent number 1 is under the custody of respondent number 2 warehouse. On 30/12/2025, a sum of rupees 30 lakhs was deposited. As he is not in a position to pay the amount, he filed WP number 1388 of 2026, seeking the relief of modification of the terms of the condition. The writ petition is disposed of, directing the tribunal to consider his request. Then the petition has filed an application on 10/2/2026, seeking for the relief of extension of time. Court, considering the said request made by the petitioner, had passed an order. Where is that?
Page number 104, my lords.
Had passed an order passed an order observing that applicant is seeking extension of time for the payment of second limb of the condition imposed by the tribunal, which mandates to pay an amount of rupees 40 lakhs on or before 31/2026. Today, the matter is taken up and gone for the applicant has filed an affidavit stating that the third and fourth limb of the conditions will be complied on due dates without seeking any further extension. And based on the undertaking, applicant seeks extension of time for payment of second limb of the condition till 27/2/2026. Considering the affidavit that is filed by the applicant, the tribunal has granted extension of time till 27/2/2026, and it is made clear that the payment is to be remitted along with the third limb of the condition. And also observe that this extension is given only based on the undertaking given by the applicant, that he will not seek further extension for the payments. Against this order, the petition is before this court. Next paragraph. When counsel appearing for the petitioner submits that the petitioner, in view of the collusion and the fraud made by the warehouse as well as the bank, is not in a position to deposit the amounts. In that regard, he has already given a complaint to the consumer forum. The same is pending consideration. In these circumstances, the petitioner requires some accommodation which was not considered by the court, which made the petitioner to come before this court. It is submitted that he has filed an undertaking at the insistence of the tribunal. Hence, is seeking interference of this court under Article 226 of the Constitution of India. Next paragraph. When counsel appearing for the respondent bank submits that the petitioner is approaching one forum after the other and stalling the proceedings, it is submitted that, in fact, there is a collusion between the petitioner and the warehouse. In fact, there is a fraud paid on the bank, and there is no material, there is no stock, there is nothing in the warehouse. It is submitted that the petitioner, having availed an interim order, failed to comply with, except the first installment, he has not paid. Then an affidavit is filed saying that he will not seek any time for the third and fourth installment, and seeking only modification of second installment, extension for second installment. Court had considered and passed orders, and now there is a sale before this court. He submits that the petition is not entitled for any relief from this court. Next paragraph. Having heard the counsels on either side, there is the material on record. The tribunal, considering the request of the petitioner, had granted stay and imposed certain conditions where he was directed to pay amount in 4 installments. He has complied with the first installment. When it comes to the second installment, he sought time, and when it was not considered, he has come before the court. And then that petition is disposed of, directing the bank to consider. Then an order is passed, observing that an affidavit is filed that he will not seek any adjournment, extension of time, and he will be paying on time the third and fourth installments. Hence, only as far as the second installment is concerned, time was granted till February. Now, again, the petitioner has come before this court. This is nothing but abuse of process of law. The petitioner cannot, the petitions of this nature cannot be entertained by the court. Already, all the courts have given a long rope to the petitioner, and no further indulgence is required to be given. Admittedly, the petitioner has not given any criminal complaint. I have not given any criminal complaint against the respondents. In these circumstances, the tribunal.
Warehouse is not a respondent in this case.
And in this case, warehouse is not
I'm
made
sorry,
respondent.
Second respondent. I'm sorry.
Don't write that. Warehouse is not a respondent. In these circumstances, this court is not inclined to pass any orders in the writ petition, and petition doesn't require any indulgence from this court. Accordingly dismissed. Yes, next.
Before Tahir.
Lordship, kindly pass, sir. Kindly pass, sir.
What password?
Senior is appearing in the division.
That's not the problem of the
Your Lordship,
court.
in this case, what happened? Your Lordship?
Does this matter after 4 weeks?
Your Lordship, kindly break it up. Lordship.
Morning, court has accommodated you by granting
Your
password.
Lordship, what
Again,
happened
now
in this
what
case? Your
password?
Lordship, Your Lordship, he is held up in division bench. Your Lordship. Kindly pass.
Let's just start it after tomorrow.
Definitely. Oblige, Your Lordship.
27. Shruti.
Appearing for the petitioner, my lordship. It's a.
Yes, where is the judgment?
It's a scheduled bank, my lordship, under the Kendra Bank, owned by government, my lordship.
Where is the judgment? No, apart from another judgment is also given of this court. Justice Narendra's judgment. Morning, somebody has passed on.
Honorable Apex Court judgment, my lord, very recent, my lord, 2025.
Yes, Shobha.
Yes, Shobha, my lord. Paras 3, 4 and 9, my lord, are relevant, my lord.
where
Muthoot Finance is not a state.
Muthoot Finance.
Article 12 of the Constitution, therefore not amenable to jurisdiction of the High Court under so and so. Very sure some all the finance company may not be strictly following ambit of state, yet being a non-banking financial institution is governed by the rules and regulations framed by the RBI. And if the statutory rules and regulations framed by the RBI are breached by a non-finance banking company, then as a statutory authority, such finance company is amenable to writ jurisdiction. We are afraid the position of law is otherwise.
But para 9 would be relevant.
Para
9, please. That the court has summed up, my lord, Article 12 and also statement.
1 minute, 1 minute. Yes.
Para 9, my lord. For issuing writ against a legal entity, it would have to be an instrumentality or agency of a state, or should have been entrusted with such functions as are governmental and closely associated therewith, by being of public importance, or being fundamental to the life of the people and hence governmental. The writ petition under 226 of the Constitution of India may be maintainable against one state government, to authority, a statutory body, an instrumentality or agency of state, a company which is financed or owned by the state, a private body run substantially on state funding, a private body discharging public duty or positive obligations of public nature, a person or a body under liability to discharge any function under any statute to compel it to perform such a statutory function. Although a non-banking finance company like the Muthoot Finance, with which we are concerned, is duty bound to follow and abide by the guidelines provided by the Reserve Bank of India for smooth conduct of its affairs in carrying on its business, yet those are of regulatory measures to keep a check and provide guideline and not a participatory dominance or control over the affairs of the company. A private company carrying on banking business as a scheduled bank cannot be treated as a company carrying on any public function or public duty. Normally, mandamus is issued to a public body or authority to compel it to perform some public duty cast upon it by some statute or statutory rule. In exceptional cases, a writ of mandamus or a writ in the nature of mandamus may be issued to a private body, but only where a public duty is cast upon such private body by a statute or statutory rule, and only to compel such body to perform its public duty. Merely because a statute or a rule having the force of a statute requires a company or some other body to do a particular thing, it does not possess the attribute of a statutory body. If a private body is discharging a public function and the denial of any rights is in connection with public duty imposed on such body, the public law remedy can be enforced. The duty cast on a public body may be either statutory or otherwise, and the source of such power is immaterial, but nevertheless there must be a public law element in such action. Accordingly, so and so.
And with regard to the Karnataka Bank, there is a direct judgment. Morning somebody gave. In the other matter, passed over matter, somebody gave the judgment. It is pertaining to Karnataka Bank.
It's not Karnataka, ma'am. It's Karnataka Gramina Bank owned by government under the Canara Bank, nationalized bank. It's 35% of shareholder. Karnataka Bank is a private sector bank. Kindly see the annexure A and B, Manaship. Karnataka Gramina Bank, scheduled bank owned by government.
Is it correct? Is it owned? It is owned by the government.
Karnataka is not owned by. It's a private bank. It's this bank is owned by.
No, the bank which she is referring.
It's a government. Karnataka Gramina Bank. It's owned by government. Scheduled bank owned by government. Rural bank.
This I am not aware. The judgment which citation to Karnataka Bank Limited.
No, whether it's a government owned bank.
Here it
says, my lord, scheduled bank owned by the government.
It says.
That they wrote in the.
In the auction sale notice, they have specified.
In that case, then it is maintainable.
Yes, my lord.
Only so far as NBFCs.
Keep this. That's what. There are so many. How many banks and institutions they are paying the? Yes.
Serial number 29. Serial number 29, my lord, had given this judgment.
So what about this? What is the relief you are seeking?
Malaship, e-auction sale, Malaship, we are ready to deposit the 7 lakhs amount, Malaship, total 48,000.
No, what is the prayer?
My Lordship, Annexure A, we are seeking mandamus. Annexure B, my Lordship, we are seeking quash.
Quash the impugned, why you should be quash the e-auction notice?
My Lordship, they have given a OTS on 30th, 12th, 2025. 1 month time is given to pay the amount. Within time, we are not able to comply. We are ready to deposit the entire.
How can the court say you extend the OTS scheme?
My Lordship, same, it's an agriculture, surface is not applicable, it's agriculture.
That is a different aspect.
Yes, my Lordship.
That's a different aspect. No, what are the reliefs you have sought? Issue a writ of mandamus directing the respondent to extend the OTS scheme. That we can't do it.
We are requesting the bank, but the.
If you request them, they oblige for your request. It is for between you
Yes, my
and the
Lordship,
bank.
but they have
There
issued
cannot
a
be any
e-auction
mandamus.
notice for an agricultural land. It's about 2 acres, reserve price is 33 lakhs, only 7 lakhs, it's their demand amount. They have a reserve price 33 lakhs, it's 2 acres more
13 to
than.
notice is given to you.
OTS notice has been given, my Lordship.
13 to notice is
No,
given.
my Lordship. Only e-auction notice, OTS scheme given on 13/12, Annexure A, my Lordship. No 13/1 notice is given. OTS given on 13/12 till.
How can it be? Without a notice to you, how will they proceed?
My Lordship, they have given a OTS. After that, they have issued a e-auction because we have not complied with the OTS scheme. 1 month time has given. Till 30th/1/2026, they have given a time to deposit the entire amount. Mean that time we are not complied.
First of all the facts are not on record. Or your client has not given you the true facts. The only remedy is you have to take a notice. I can't grant any order.
1 week, date may be
The
given.
petitioner is permitted to take out hand summons on the respondent bank and shall file a memo to that effect. Once a memo is filed, list the matter. Yes, next.
Action on 12th, kindly have 10th, my Lordship, before
10th.
10th.
Yes.
29. Mohan, petition. This is on NBS, MDX.
This judgment squarely applies to your case.
Correct, man, but in that matter, my lord, gold on what they have.
No, it is not about gold loan.
No, I got it, I concede, my lord. I also read the judgment under Article 12.
First of all, Shamman Capital Limited, how is it?
I agree, man. I agree. I read the judgment also, Honorable Supreme Court judgment. I read, not coming within the purview of the state definition of state. So, my lord, we have to approach the Honorable DRT. But I may make submission, my lord. Petitioner number 2 is the student, my lord. He just crossed 18 years. He's today is first subject exam.
You also seen
some protection, my lord. We will approach the DRT.
When the writ itself is not maintainable, question of granting interim order will not arise. That's the practice. Recently, the Honorable Apex Court has deprecated. You must have seen the judgment. When you say it is not maintainable, how can you give any benefit, an interim benefit to the party?
My lord, it may be considered filing in a wrong court, my lord. We'll go and present the.
Go there. We
meantime,
can't.
my lord.
We can't.
At least 1 week, my lord.
The
Considering the fact, my lord. My lord. For a moment, my lord. For a moment. Just see today is the first examination for the first petitioner number 2, my lord. He is a student. If there is a fear or threat of disposition, my lord. They have taken position. They have re-granted the position, my lord. You have paid 15 lakh rupees on 18th when they taken the position. After we paid the amount, they
we can't
redeliver the position, my lord. There is considering that the exams are on my lord. Today it is he will not be able to prepare for the exams. This thing, my lord. Consider.
That's not the problem of the court. The present petition is
limited protection, my lord.
Seeking the following prayer. The respondent is.
All ticket also we have filed,
Capital Limited.
Today is his first exams.
The Honorable Apex Court in Shobha versus Muthoot Finance Limited has held that the writ petition against a finance company is not maintainable. And it paragraph number 9 has laid down these guidelines. Extract para number 9. In the light of the above, this writ petition is not maintainable for this court. When counsel for the petitioner submits that one of the petitioner is the student, and if they disposes during his examination time, it would cause a lot of hardship to the petitioner, and some protection may be granted to approach the Honorable DRT, approach the DRT. When the writ petition itself is not maintainable before this court, question of granting interim protection would not arise. This practice is deprecated by the Honorable Apex Court in the recent judgments. In that view of the matter, this court do not find any reasons to interfere. Accordingly, writ petition is dismissed as not maintainable before this court. and the petition is at liberty to avail the appropriate remedy.
All question may be kept open.
Yes.
31, Prasanna Kumar.
For petitioner in this matter, my lords, wherein petitioner number 1 has taken 30 lakhs loan and he has discharged the liability, my lords.
Which is the respondent?
Sri Guru Raghavendra Sahakari Bank Niyamita, my lords. My lords, he has
Same
discharged.
judgment will apply to you.
Yes, my lord, he has discharged the entire loan liability, my lords. In the
Please
year
understand,
2020.
you can't
Yes, my
maintain a
lords.
writ petition. Please come.
My
The
lords,
present writ petition is filed, seeking the
lords,
following prayer.
one submission, my lords. In the, even Supreme Court has held that merely because the writ petition is not maintainable, in exceptional cases,
Writ petition is not your judgment which you are relying on is altogether on a different footing. When you have an alternative remedy of going before DRT, when you file a writ petition before this court, because of an alternative remedy, this court cannot dismiss the writ petition. When writ petition itself is not maintainable, again it's a particular entity, you can't come. The judgment won't help you.
yes, my lords.
The present writ petition is
As it
filed,
is,
seeking
my
the
lords, at
following
least
prayers.
interim.
The respondent is Guru Raghavendra Sahakara Bank Niyamita. In the light of the judgment of the Honorable Apex Court in so and so, the present writ petition is not maintainable. The Honorable Apex Court in the above said judgment at paragraph number 9 has observed as follows, extracted in that view of the matter. The writ petition is not maintainable,
Submission,
and the
my lords.
petition has to avail the appropriate remedy before the appropriate forum.
Submission, my lords. At least 1 week time, my lords, not to take any coercive action, my
We
lords.
can't give, please understand. Yes, next.
39, Mallikarjunaya.
30.
9.
The judgment you keep it. Yes, 39.
I'm for respondent number 1, my last.
Lordship, I appeal for petitioner. The tribunal has passed an order on question of limitation. The appeal was filed before the.
I'll hear it because I have a full bench now. I have a full bench. It may take time. Let's just matter day after tomorrow. Yes, next.
Lordship, after 15th.
Huh?
12th, after 12th.
Unnecessarily, they are taking so many adjournments. Kindly see the order sheet.
Adjournment. We have filed the legal objections in the last one.
What do you want?
After 12th date.
No. Yes.
Day after tomorrow, my Lordship, day after tomorrow.
Interim order may be extended, my lordship.
Tomorrow, day after tomorrow.
Lordship, interim order may be extended.
It will be extended. Yes, next.
48.
40?
Pratima, 48. Pratima K, SK.
Where is he?
He has been watching the proceedings. I think whenever the court takes it up, he comes running. This has happened the second time, lords, if I'm not mistaken.
This is matter. The morning when the court was dictating the order, half the way, the petitioner who was sitting in the court comes to the, and then he submits that he's appearing. When what is?
Appeal for respondent, Your Honor.
What is happening?
Sorry, Your Honor, I was outside.
Tomorrow, list this matter as first matter. I'll pass orders. And now when the matter came up, initially there was no representation. Then it is submitted that the counsel is on before the other court. This is matter tomorrow. I'm going to pass orders tomorrow. I'll not hear any argument also. Yes.
Great.
Signatures? Give that. On behalf of the petitioner. Same order in that also.
Youth matter ಆಗ್ತಾ ಉಂಟು regular ಆಗಿ. ಇದನ್ನ ಆಯ್ತು, ನಾಳೆ ತರ್ತೀರಾ? ಹೌದಾ? ಆಯ್ತು, ಥ್ಯಾಂಕ್ ಯು. ಮಾರಿ ಎಷ್ಟು ಹಾಕ್ತಾರೆ? ಕಡಿಮೆ ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ. ಆಲಿಯರ್ಸ್ DRT ಆಲಿಯರ್ಸ್ ಇದೆಯಲ್ಲ, ಮೊದಲು ಇವ್ರು DRT ಬರ್ತಾ ಇತ್ತು, ಹಂಗಾಗಿ ಜಾಸ್ತಿ ಬರ್ತದೆ. ಇಲ್ಲ, 50 ಮೇಲೆ ಫುಲ್ ಕೋರ್ಟ್ ಇದೆಯಲ್ಲ, ಅಲ್ಲಿವರೆಗೂ ಹೋಗಲ್ಲ. 3 ವಾರ ಇರುತ್ತಂತೆ, 3ವರೆಗೆ ಇದ್ಬಿಡ್ತಾರೆ. ಇಲ್ಲ, ಅವರು ಚೇಂಬರ್ ಇಂದ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಹೋಗುತ್ತೆ, ನಮ್ಮ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಲ್ಲ. ಅವ್ರು ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಲ್ಲ, ಅಲ್ಲಿ ಚೇಂಬರ್ ಇಂದ ತಗೊಂತಾರೆ. ನರೇಂದ್ರ ಸಾಹೇಬ್ ಡಿಸ್ಮೆಂಟ್ ಅಂತಾರಲ್ಲ, ಇದೆಯಾ ಸರ್? ಇದ್ರದ್ದೇನೆ ನರೇಂದ್ರ ಸಾಹೇಬ್ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರಿಂದ ಬೆಳಗ್ಗೆಯಿಂದ.
ಅರವಿಂದ್ ಅವ್ರದ್ದು ಇದೆ.
ಇದು ನೋಟ್ಸ್ ನೀವೇ ಇಟ್ಕೊಂಡ್ಬಿಡ್ತೀರಾ? ಏನ್ ಮಾಡೋದು? ಪೈಲು ತಿಡಂಗಿಲ್ಲ ಆಗ್ತದೆ.
ಅಲ್ಲ ನರೇಂದ್ರ ನಮ್ ಕೊಡ್ತಾ
ಏನು
ಕೊಡ್ತಾ ನರೇಂದ್ರ ಸಾಹೇಬ್ರು?
ನರೇಂದ್ರ ಸಾಹೇಬ್ ನಮ್ಗೂ ಐ ಕೊಡ್ದೆ.
ಇನ್ನೊಂದು ಅಲ್ಲ, ಅದೊಂದು ಮತ್ತೆ ಇನ್ನೊಂದಾಗಿದೆ ಮೇಡಮ್.
ಅದೇನು ಕರೆಕ್ಷನ್ ಮಾಡ್ಕೊಟ್ಬಿಡಿ ಹೋಗಿ. 16 ಹೊಡೆದಾಕ್ಬಿಟ್ರ? ಅದೆರಡು ಹೊಡೆದಾಕ್ಬಿಟ್ರ?
ಇದು ಹೊಡೆದಾಕಿದ್ದೀನಿ ಕರೆಕ್ಷನ್ ಮಾಡಿ.
ಸೇವ್ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ.
ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಅಲ್ವಾ? ದೊಡ್ಡ ಮಾಡ್ಬಿಟ್ಟು ಸಿಗ್ನೇಚರ್ ಮಾಡಿ
ಇದೆಲ್ಲಿ ಫೈಲ್ ಇದೆ? ಇದು ನಮ್ಗೆ ಅಲ್ಲೇ ಕಳಿಸ್ಕೊಡಿ. ಫೈಲ್ ಅಲ್ಲೇ ಇದೆ. Obliged to all instructions. ಹೇಳಬೇಕಲ್ಲ, ಎಲ್ಲ ಕಡೆ ನಿಮ್ದೇ ನಡೆಯೋದು.
ಕೊಡ್ತೀನಿ ಸರ್ ಬೆಳಿಗ್ಗೆ ಅದನ್ನು.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ನರೇಂದ್ರ ಪ್ರಸಾದ್ ಸಾಹೇಬ್ರು ತಾನೆ? ನರೇಂದ್ರ
ಪ್ರಸಾದ್ ಅಲ್ಲ, ನರೇಂದರ್ ಅಷ್ಟೇ.
ಹಂಗಾರೆ ಇನ್ನು ಸ್ವಲ್ಪ ಹಳೇದದು.
ಅವ್ರ ಮೇಡ ಸಾಹೇಬ್ರು ಆ ಕಡೆ ಹೋಗ್ಬಿಟ್ರಲ್ಲ, ಬೇರೆ ಡಿಸ್ಟಿಕ್.
ಗೊತ್ತಾಯ್ತು, ಅರ್ಥ ಆಯ್ತು ಬಿಡಿ. ಜಿ ನರೇಂದರ್.
ಅಂಡರ್ಟೇಕ್ಸ್ ಟು ಫೈಲ್ ವಕಾಲತ್ ಇರ್ಬೇಕಲ್ಲ. ಅಲ್ಲಿ ಅನಿತಾ ಬರ್ತಾರೆ ಅಂದ್ರು, ನೋಡೋಣ. ಅನಿತಾ ಸೀನಿಯರ್, ನಮ್ಮ ಸೀನಿಯರ್ ಇರ್ಬೇಕಲ್ಲ ನಮ್ಮ ಕ್ಯಾಂಪಸ್. ಜಿ ನರೇಂದ್ರ
ಸಾಹೇಬ್ರ ಎರಡು ಕೊಡ್ತೀನಿ, ಸಿಕ್ತು ಅಂತ ಹೇಳಿ ಬೆಳಗ್ಗೆ ಕೊಡ್ತೀನಿ. ಎರಡು ಇದಾವೆ.
ನಂಬರ್ ಇದೆ ಕೊಡಿ, ನಾವು ತಗೋತೀವಿ.
ತಗೊಳ್ಳಿ, ನಮಗೆ ಸಿಗದಿರೋ ಯಾವ್ದು?
ಎಲ್ಲ ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ಅಲ್ಲೇ ಇರುತ್ತೆ ನಿಮ್ಗೆ.
WP 11869 of 2017. 869 of 2017. ಆಯ್ತಾ, ತಗೊಳ್ಳಿ. ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್ ಇದು.
ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್
ಇದನ್ನು ಮತ್ತೆ ಅದನ್ನು ಕೊಡ್ತೀನಿ ಬಿಡಿ ಪ್ರಿಂಟು. ಕನ್ನಡ ಬ್ಯಾಂಕ್ ಎರಡನ್ನು.
ಹಳೆ ನೀವು ಒಂದ್ ಸೆಟ್ ತಗೊಂಡ್ಬಂದಿರಿ.
ಅಲ್ಲ, ನಮ್ದೇನ್ ರೋಲ್ ಇರಲ್ಲ, ಬಟ್ ಅಸಿಸ್ಟೆನ್ಸ್ ನಮಗೆ ಹೆಲ್ಪ್ ಮಾಡಿ. ಎರಡು ಕೊಡ್ತೀನಿ. ನರೇಂದ್ರ ಸಿಕ್ತು. ಜಿ ನರೇಂದ್ರ ಜಜ್ಮೆಂಟ್ ಸಿಕ್ಕಿದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
He has held that the Karnataka bank is not a bank in terms of Article 12 of the Constitution of India.
ಅದೆಲ್ಲ ಹೇಳಿದಾರಾ? ಓಕೆ ಸರ್. ಏನ್ ಕೇಳಿದ್ರೆ ನಿಮ್ ಫೋನ್ ನಂಬರ್ ಕೊಡಿ, ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ನಿಮ್ಮನ್ನೇ ಕೇಳ್ತೀನಿ ಹಂಗಾರೆ.
ಆಮೇಲೆ ಬುಕ್ಸ್ ಬೇಕಂದ್ರೂ ಅಲ್ಲಿ ನಿಮ್ ಬುಕ್ಸ್ ಪಬ್ಲಿಕ್ ಪ್ರೈವಸಿ ಆಕ್ಟ್ ಇಟ್ಕೊಳ್ಳಿ ಸರ್. ಆಮೇಲೆ ಫಾರೆಸ್ಟ್ ಆಕ್ಟ್ ಇಟ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಪೊಲೀಸ್ ಆಕ್ಟ್ ಇಟ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಕರ್ನಾಟಕ ಸೊಸೈಟಿ ರೆಸ್ಟ್ರಿಕ್ಷನ್ ಆಕ್ಟ್ ಇಟ್ಕೊಳ್ಳಿ. ಏನಿಲ್ಲ ಪ್ರೊವೈಡೆಡ್ ದೇ ಶುಡ್ ಸಿ ಮೈ ಐ ಕಾರ್ಡ್.
ಫಾರೆಸ್ಟ್ ರೆಗ್ಯುಲೇಷನ್ ಅಂತಿದೆ 1900 ಹಂಗೆ ಏನು ಬೇಕು ಪ್ರೊವೈಡೆಡ್ nine five 9854 98 okay thank you ಗಂಗಾಧರ ಏನ ಮಹಾಂತೇಶ್ ಶೆಟ್ಟರ್ ಅಲ್ಲ ಸರ್?
ಮಹಾಂತೇಶ್ ಶೆಟ್ಟರ್, ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್. ನಿಮ್ಮ ನಾಮಾಂಕಿತ ಹೇಳ್ಬಿಡಿ ಸರ್ ಒಂದ್ಸರಿ.
ಗಂಗಾಧರ.
ಗಂಗಾಧರಯ್ಯ.
ಗಂಗಾಧರಯ್ಯ.
ಸೇಮ್ ಅಂತ ಹಾಕೊಂತೀನಿ.
ಸಿಎಂ.
ಹಾ.
ಅವ್ಯಾಕೆ ಸರ್ ಸಿಎಂ ಆಗನ?
ಕೋರ್ಟ್ ಮಾಸ್ಟರ್ ಅಂತ.
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಇದನ್ನ ಈಗ 17 ಅಂತ ಹಾಕೊಂಡಿರ್ತೀನಿ. ಹಂಗ ಹಾಕೊಳಕ್ ಬರಲ್ಲ, ಮತ್ತೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. 17ಕ್ಕೆ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಇನ್ನೊಬ್ರು ಬರ್ತಾರೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅಂತ ಹಾಕೊಂತೇನ್ರಿ ಮೇಡಮ್. ದೇ ಆರ್ ಆಲ್ ಆಫೀಸರ್ಸ್, ನಾಟ್ ಮಾಸ್ಟರ್ಸ್. ಕರೆಕ್ಟಾ ಸರ್? ಥ್ಯಾಂಕ್ ಯು.
ಮಾಸ್ಟರ್ ಆಫ್ ನನ್ ನಾವು.
ಎಸ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಎರಡು ತರ್ತೀರಿ, ನಾನು ಬೆಳಗ್ಗೆ
ತಂದ್ಕೊಡಿ ಸರ್. ಹಾಕೋರ ಅದು ಒಂದೇ ಸರಿ ಜಡ್ಜ್ ಆಗ್ಬಿಡ್ತಾರ ಒಂದ್ಸರಿ. ಅವಾಗ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಹೇಳ್ಬಿಡು. ಮೇಡಮ್ ಅವ್ರಿಗೆ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಬಿಡೋರಲ್ಲ. ಆಫ್ ನಾಳೆ ಎಷ್ಟನೇದು? ಎಷ್ಟನೇ ತಾರೀಕು? 4 ಬೇಗ ಬೇಗ ಓಡ್ತಾ ಇದೆ ಕಾಲ. ಅದೇ ಮಾರ್ಚ್ ಆಯ್ತು. ಯಾವಾಗ ಮಾಡಿಸ್ತೀರಾ ಪೇ ಸ್ಕೇಲ್ ನಮ್ಗೆ? ಬೇರೆ ದೇಶಗಳು ಬಿಡಪ್ಪ. ಮುಸ್ಲಿಂ ಕಂಟ್ರಿ